The impugn orders are set aside. Matters remanded back to the disciplinary authority to pass appropriate penalty. Except the penalty of dismissal, removal from service. And the authority shall determine the entitlement of the petitioner as per law.
Obliged.
May I please on. My lord, this contempt petition has already filed, my lord, and numbered also, my lord, but not listed, my lord. May I pray, my lord, for tomorrow, my lord. Some urgency is there, my lord.
All right.
Deeply obliged.
Item 16 of today's list listed for hearing. Lordship, the thing is that, Lordship, the issue before this in the writ petition is already being pending by way of writ petition 6/2019, C Binod, before the division bench, Lordship, and DSA is appearing there, Lordship. So I think, Lordship, until that matter get disposed. This
16. You are for the
issue is pending before the division bench, Lordship.
I understand. You are for the petitioner.
No, for the government.
Any objection?
Like that aspect of the matter has been recorded in the last order itself.
So when do we list it?
After the
That matter was listed after yesterday, and this matter may kindly take up the Lordship after the puja application, Lordship. Let's give it a try.
Item 16, please write counsel for the petitioner, counsel for the parties, submit that. The issue involved in a similar matter is pending before the division bench of this court, and pending disposal of the same, the instant matter may be adjourned. In view of above, matter stands adjourned to be listed again after the puja vacation.
Lordship.
May it please the Lordship, item number 3, with the consent of the petitioner.
Which item?
Item number 3.
3. Yes. What do you want?
Your Honor, due to some personal inconvenience, my senior, with the consent of the petitioner, I beg to mention
You are for the
respondent.
respondent bank.
Bank.
You have taken consent?
Yes, Your Honor, we have taken consent.
When do you want the
This
matter?
matter may be fixed, Your Honor, after vacation.
Okay. On the prayer made by the learned counsel for the respondent bank and not objected to by the other side, list the matter again after the puja vacation.
Obligation.
May I please your lordship, with the consent of other side, I beg to mention item number 17, lordship. So hearing matter, lordship, my senior is severely ill, lordship, is suffering for fever. So lordship, next week.
17,
Yes, lordship.
you are for the petitioner,
Yes, lordship.
respondent,
Comment,
one.
lordship.
counsel for the petitioner, Mr. What is his
On
name?
behalf of UJ Soikia, lordship, my name is.
Mr. UJ Saikia is said to be indisposed. Stop on a prayer made on his behalf. Matter stands adjourned
We
for a week.
publish, lordship.
May I please, your lordship? Lordship, I beg to mention item number 25 and 26 of today's list. Also, I have to seek some instruction whether any relief has been granted to the petitioner. So kindly lordship may take up this matter.
You're for the petitioner?
Lordship.
Counsel for the petitioner submits that he may be granted some time to find out as to whether relief has been received by the petitioner or not, and for which he seeks a week's time,
Lordship, it will be taken up in the first week of October.
and for which he seeks for 3 weeks' time. Today is what? 13,
It is
12.
12.
Okay, and for which he seeks for 2 weeks' time. List the matter again on first
Okay,
of October.
deeply obliging.
May this lordship, with due consent from the other side, I beg to mention item 15, 15. My senior R. Mazumdar is out of station. I pray for the adjournment for a day.
What about the other side?
A respondent, ma'am.
Any objection?
No, ma'am.
Mr. R. Majumdar, the conducting counsel for the petitioner, is said to be out of station on a prayer maiden's behalf and not objected to by the other side. Matter stands adjourned for
After 2 weeks,
2 weeks.
obliged.
15, 15.
May I please, your lordship? Lordship, I'd like to mention item number 18. The counsel for the petitioner is unwell and matter may be kindly listed after the vacation.
Who is unwell?
Mr. A.K. Prakash, counsel for the petitioner,
When do you want it?
after the vacation.
Mr. A.K. Prukasthya, learned counsel for the petitioner, is said to be indisposed. Stop on a prayer made on his behalf. Matter stands adjourned to be listed again after the puja vacation.
Right.
Yes. Court Master.
On last occasion, a direction was issued to produce the relevant documents pertaining to the recruitment release.
Relevant documents
Yes,
pertaining to,
records.
Pertaining to recruitment process.
what is the case regarding?
The case is regarding your lordship. The petitioner had applied for a post of Havildar in the Assam Rifles. Pursuant to the advertisement issued by the Assam Rifles. Petitioners have apparently admittedly appeared and passed all the relevant exams like PET, skill test, written examination, detailed medical examination, and food test, detailed medical examination. Thereafter, what happened, Your Lordship? The private respondent number 7, who failed in the skill test, he was, his name was published in the final merit list instead of the petitioner, even though he did not clear the skill test.
How many private respondents are there?
Only one, Your Lordship.
How many candidates participated?
For Uttarakhand, there were many, but for Uttarakhand, only two posts, only one post was there.
5 candidates
State.
are applied for Uttarakhand. 5 candidates as per record for Uttarakhand, state of Uttarakhand.
This is for Uttarakhand.
Yes, this is for
How
Uttarakhand.
many quota are there? Quota
Only
is there?
one.
Only one post. So how many were selected?
Only one selected.
That is the private respondent number 7.
Yes, yes.
And according to the petitioner, despite having not passed the trade test,
No, my lord. We have record, in merit list, he is,
what is the test? Which according to you, he has not cleared.
In a minute, there was a test for skill test where in a minute, he has to type 35 words. A candidate has to type 35 words in computer, but he failed to do so.
What is the post?
Havildar.
Havildar. They're supposed to type also.
Yes. Typing test is there.
It's not a clerical post.
Yes, clerk Havildar.
Clerk Havildar, that's why. So he failed in the skill test, in the typing test.
The respondent number 7, yes.
Despite that, he has been appointed.
Yes.
Okay. What is the marks given? How is it given?
It is just pass or fail. No marks is given.
Then how do you say that he is not passed?
Lordship, when exam was happening,
Ah.
it was in the same room. There is a software through which they count how many words is typed.
Hmm.
So at that point, he was not able to type 35 words in a minute. Despite that, they allowed him to appear in the detailed medical examination.
No, but where is the evidence to that effect that he has not passed?
That is, they will, Your Lordship.
You're making an allegation. You're the one who's making an allegation that he has not passed.
I have also applied. for
On
the
what
RTI.
basis you're saying that?
Your Lordship may kindly. Peruse page 84
What is that?
of their reply, affidavit in opposition.
No, before that, let us come to your averment. Where have you made the averment that he has not passed?
I have made in my writ petition. Your
Yeah, show me which paragraph.
Lordship, para 8.
Please read.
That the petitioner begs to state that subsequently the respondent authorities declared the final result of the recruitment through a list of provisionally selected candidates, Assam Rifles Technical and Tradesmen's Recruitment Rally 2017. Surprisingly, the petitioner name was not there in the state list, even after performing well and qualifying in the skill test. And on the other hand, respondent number 7, that is Mr. Narendra Singh, ID number name was included even though he was not able to type 35 words in English in a minute, which was the eligibility criteria to qualify the state skill test.
And to support your averment, what have you annexed?
So, Lordship, I have filed the RTI, I have written many. They have not provided me my skill test dossier also, saying we are exempted.
Where is your application?
RTI application. Page 71 is the reply.
Where's your application?
Page 69.
59.
Page 67 is there. 67, your lordship. Please provide photocopies of written examination answer sheet of ID number and ID number. Please provide photocopies of skill test documents of ID number and they replied only one.
This, please provide photocopies of written examination answer sheet of ID number 2131.
Yes.
Who's this?
This is mine, your lordship.
And 200125?
That is of private respondent number 7.
7. Yours and his, you have asked both.
Yes.
You have not been given.
No. They replied that
They are exempted.
after that we filed they replied that only one vacancy of clerk rate for general category was advertised against Uttarakhand state. The same vacancy was filled up by appointing a meritorious candidate from as per the advertisement. You could not be selected due to low in merit. That was the reply. Then we filed appeal against the application. Then they replied that we are exempted from providing the information.
That's page 71.
Yes, your lordship.
Okay. Now, what is the scheme of the exams otherwise? That you have to type this much words per minute.
Yes, your
Has
lordship.
it been given anywhere
Yes,
in the advertisement?
yes, yes.
Please show me. Does it start from annexure 1?
Your lordship may kindly peruse page 26.
26, serial
Yes.
number?
1. Clerk Havildar,
Mhm.
skill tests norms on computer. English typing with minimum speed of 35 words per minute on computer. Hindi typing with minimum speed of 30 words per minute on computer.
Which one is relevant to your case?
B, your lordship, 1B, skill test.
English typing with minimum speed of 35 words
Yes, your
per minute. So your specific averment is that respondent number 7 could not type 35
Yes.
words per minute.
yes,
Despite that, he has been selected.
yes.
Yes, Ms. Gayan, do we have the records?
Yes, the records and also annexed in my affidavit in revision page 56. That is the result of skill test
Page 56.
of my affidavit in opposition.
What is the page number?
Page number 56 of my affidavit in opposition. Can you please- Annexer R6, page 50, starting page number 55, Annexer R6.
Yes.
That is, my lord, in the 56 is that consolidation result of the trade test.
Which means the typing test.
Yes, typing test. And he's 57, the relevant portion is 57, serial number 348 and 351. 348 is the respondent number 7.
Petitioners at serial number,
Petitioner is in serial number 351, last one.
351.
351, Sanjay Singh Gangola. According to record, he passed the trade test, and the respondent number 7 is 348,
Narendra Singh.
Narendra Singh. He also passed the trade test.
Trade test means that typing test.
Typing test. Now kindly see.
Now in the records, do you have the assessment made? How many words and all that?
In the record, they reflect the total, they reflect the marks obtained in written examination.
Do one thing, you just find it out,
Yes, sir.
you flag it up,
Yes, sir.
we'll take it up again after some time.
Yes, sir.
The affidavit is ready, my lord. We have sent letter for swearing. My lord, we have not received any response. My lord, under 2 weeks time will be given to swear. the, my lord,
20
the
matter, my lord.
affidavit.
Remove from service, the policeman. Anyway, let them take 1 week time. It is ready.
Mr. Shutia,
From Dhebaji, my lord, 1 week may not be, my lord. Today I will write.
No.
They will have to come, my lord.
you have prepared the affidavit?
Yes, the draft is ready, my lord. We have sent it in the email also, my lord.
Okay.
I will receive it soon, my lord.
Have you served an advance copy?
My lord, this copy is only, no, my lord.
No, affidavit is, if the affidavit is ready, you serve him an advance copy. You can file it.
Only one copy, my lord. It is not signed by a deponent, my lord.
Mr. D. Chutia, learned senior government advocate submits that the affidavit in opposition has been prepared and he needs how much time?
2 weeks time, my lord.
10 days,
10 days.
10 days time to file the same, since the deponent is supposed to come from Dhemaji. Mr. R.P. Sarma, learned senior counsel, expresses urgency in the matter, stating that the petitioner is out of service and therefore the matter may be heard
On 26th, my lord.
as early as possible.
26.
26th,
Next
no,
para,
it is
considering the submissions made, list the matter.
26th, my lord. It is more than nearly 2 weeks. 14 days is getting clear. It will be 2 days, 15 days.
Yes, list the matter again on 26th of
Obliged.
September.
Obliged.
My lord, item number 5 be taken fast item, my lord, that will lead the case, my lord. Yeah, my lord. No, item 5, please. my lord. Sharma, my lord. Lordship, kindly take up item number 5, my lord.
Now, as per the last order, there was some direction.
There was some direction was given to both the parties, my lord,
Have you
to
complied?
ascertain the what law is governed, my lord.
Yes.
So far, my understanding and I have instruction, my lord, it is governed by the rule, my lord, of 2073, my lord.
2073?
Oh, sorry, my lord. 1973, my lord. That is, my lord, Assam Directorate Establishment Ministerial Service Rule 1973.
Who's for the other side?
Other side, my lord, all the sides name has been shown, my lord. PHU is also there, government is also there, personal department is also there. এই কিতাপটো আছে। Page 163, my lord, be seen, my lord. But it has to be ascertained by the department or by the government. Page 167.
What is the name of the rules?
Assam Directorate Establishment Ministerial Service Rule 1973.
Okay, now where is the relevant portion?
Relevant portion, my lord, how the promotions are to be carried out. That is, my lord, Rule 10 at page 174 and 75, my lord. 10(3), my lord. Page 175.
Junior assistant.
My lord, dealing assistant, my lord, is a grade 3 post, my lord. Lordship, kindly have a look.
No, dealing assistant or junior assistant?
This is a junior assistant, man. My next promotion is a grade 3, my lord, as like junior assistant. It reveals, my lord, by selection on the basis of suitability with regard to the seniority from amongst grade 4 staff of office who passed number 1 higher secondary or equivalent examination and have rendered not less than 5 years. Number 2, matriculation or equivalent of examination of have rendered not less than 7 years of continuous service in the office of first day of so and so. These are the procedure, my lord, follows. Kiba paisa nahi? Huh? Ki rule?
Petitioners are working under which department?
PH department under the executive engineer, my lord,
PHE.
PHE. And my lordship, kindly have a look, item page 25 of item number 5. In pursuance to the additional chief engineer number so and so, Assam Guwahati due to so and so, and my name appeared at my lord 27 for item number 5. Item number 5, my lord. Serial number 27 at page 25.
Serial number 27.
My lord.
Dilip Sharma
Dilip Sharma,
is the petitioner.
petitioner, item number 5.
Okay, and what is this list?
This list, my lord.
Khalasi.
They have been regularized, my lord.
Name of Khalasi.
My lord, Khalasi, they have been regularized. And thereafter, my lord,
Just a minute. Regularized with effect from
I'll just read, my lord, by letter number so and so 2003, following charged employees of different categories under the division hereby regularized in the scale pay of so and so for up to 2004 with effect from 1/12/2003. First paragraph,
your regularization is only up to certain period.
no, my lord, from that period, and I
I-
have been given increment also.
Are hereby regularized in the scale of pay as shown below for the period up to 28 to 2004.
For with effect from But thereafter, I'm receiving, my lord, increment also,
This order is of 19/12/2003.
my lord.
Effective date is from 1/12/2003.
See,
You are a Khalasi,
Allah say that I
serial
have
number
been-
27.
Yes, my lord. I have been regularized.
So how many years you have served now?
Now, my lord, I'm working since then, my lord, right from my appointment till date. I'm working.
Your appointment was
My appointment was Khalasi, my lord.
when?
2000, I have stated, my lord, in para 2 of my petition, my lord.
Yes, what is the
Page
date?
7, lordship, can you
What-
have a look?
What is the date?
Petitioner backs to the petitioner is working Khalasi under the office of the executive Gwalpara division prior to 1993. The service of the petitioner was regularized by the order dated number 19/12/2003. Executive engineer Gwalpara division in persons to the additional chief engineer's letter so and so. So I have been appointed prior to 1993. Regulation has occurred place by the annexure 1. By the annexure 1,
You were just reading paragraph?
paragraph 2 of my writ petition. Lordship has come across. That the petitioner begs to state that the petitioner is working as a Khalasi under the office of the executive engineer, PHE Gwalpara division prior to 1993. Service of the petitioner was regularized by the office order number 178 dated 19/12/2003.
So as per the service rules, what is the criteria?
Criteria, my lord, those who are higher secondary, for them it is 5 years. Those who are HSLC, 7 years continuous service in the office. Then, my lord, it will be recommended for selection committee, my lord. Then the promotion will be offered. Lordship,
Petitioner
can you
is
have a
what?
look, my lord? Annex,
What is the qualification of the petitioner?
petitioner is, my lord, all matriculate maybe. দিছা নেকি?
All the petitioners are matriculate.
এটা আছে নেকি দিক? এটা? বেলেগ ফাইলটো চোৱা নাই। আৰুতো petition আছে, পেৰা ক'লে হ'ল। From annexure 2, my lord, their qualification can be revealed, my lord. Lordship will see page 27. Page 27, my lord. Serial number 5.
Yes.
Serial number 5, Khalasi, date of birth, date of retirement, then date of joining. Then lordship will see that read are in HSLC standard 10 from Board of Higher Secondary School, Delhi, Niki. Delhi.
What is page 27?
Page 27 is the gradation list prepared by them, my lord.
And petitioner appears at serial number?
Serial number 6. Dilip Kumar Sharma, Khalasi, and my qualification read in HSLC E standard 10 from the Board of Higher Education, Delhi. Maybe CBSE.
HSSLC.
My lord. Matriculate. means,
It's +2.
My lord, +2, +2. Then
HSSLC means matriculate,
Yes,
not
ma'am.
matriculate.
higher
+2,
secondary,
higher secondary.
yes. That,
Now you come back to the rules.
rules, my lord. Rule 10(3) says, my lord, selection on the basis of suitability
with regard to the seniority from amongst grade 4 staff of the office who passed higher secondary or equivalent examination or have been rendered not less than 5 years or matriculation or equivalent examination have rendered not less than 7 years of continuous service in the office of the day of first year, which was the selection is made. 5% and 10% of the strength of the cadre of the junior assistant be less than 1, and 1 post should be filled up by sub-rule 2. And my next promotion is a grade 3 post, my lord, equivalent to junior assistant.
So from grade
Four
to grade
to-
4 to grade 3,
3, my lord.
promotion.
Fine.
Now,
They
the-
have selected also.
just a minute. Now the criteria is like that.
My lord.
And the percentage which can be filled up is 10% of the vacancies.
My lord.
That means 90% is direct recruitment,
Min-
10% is by promotion. And it also says that if there are no sufficient numbers of candidates to be filled up by promotion, it should be filled by direct. Your case is that you should be promoted.
my lord.
You
Eh,
have-
what
you
my
have-
case is, my lord,
You, just a minute. You have entered service before 1993.
my lord. I
You
joined
were
service
ultimately regularized in 2003.
93.
And as on today, you have served more than 23 years
My lord,
on regular basis.
my lord.
Now, next question which comes is, what about the vacancy position?
Vacancy is there, my lord, because my name has been recommended for promotion, my lord. Approval was sought for from the office of the chief engineer. Chief engineer said, my lord, that it is a personal post. That's why my case was not considered. Now question comes, my lord, from their own notification, I have filed my additional affidavit. Lordship, kindly have a look. My additional affidavit, which I have filed, by virtue of which my service was regularized. I filed on 25/6/24. Page 66. And minutes itself reveals the vacancy position. That point I'm coming, my lord. Lordship, have a look, page 66. May I read, my lord, operative part? Sir, I am directed to convey the sanction of the Governor of Assam for creation of 4961 post so and so of different categories as shown in the statement at Annex 1 to regularize the service of 4961 numbers of workers employed by the name who were engaged by PHE department under general areas prior to 1493 in the usual scale pay prior to ROP revision of pay rule, my lord, of 1998 for the period up to 23 to 2004 with effect from 1/12/2003, abolishing the same numbers of workers employees in different categories simultaneously. These posts are created subject to the following condition. Number 1, creation of 4961 number of regular posts equal number of workers post will be abolished immediately. These regular posts are created by the name. This is important, minded, by the name against this workers employee, and these posts will get abolished automatically as and when concerned employee is retired, promoted, or died.
So,
There is a provision for promotion.
no, you are also one of the appointee
Yes,
on this 4961 post created.
yes.
So these are personal posts.
But my lord, there it is serial number 2, lordship, can you have a look? These regular posts are created by name against each workers employee, and these posts will get abolished automatically as and when concerned employees retired, promoted, or died.
Hmm.
Either I have to retire, I have to be promoted, or I have died. Then my lord, post will be abolished. Meaning thereby provision is there for promotion. And similar circumstances case, my lord, lordship, kindly turn to page 68. 68, lordship, kindly have a look. Same division, my lord, they have caused promotions.
Yes, who's there in 68?
Page 68, my lord, there are 8 number of persons, or 50 number of persons, my lord, they were promoted as like the petitioner. May I read, my lord?
Promoted from what post?
From Khalasi to grade 3 pump operator like instant petitioner.
They are also similarly situated.
Yes, yes, similarly. That has been issued on 2020. Lordship, kindly may I read, my lord?
It's okay, no, don't read. Now, where,
Now another is also there, my lord.
no. Where is their origin, these people, 15 persons?
15% they were Khalasi, my lord.
They were also appointed against the 4961 post created.
Yes, yes.
Now, how do you connect them to this 4961?
4961, my lord, it is the best person by the government, they have to ascertain, my lord. Now, lordship, another thing, lordship, kindly have a look at page 69. It is recent order, my lord. Page 69, one Chinmay Chakrabarti, grade 4, has been promoted to junior assistant.
This is as per the High Court's order,
Yes, my lord.
in writ appeal number 49.
Yes, yes. Thereafter, my lord, page 70 also, lordship, kindly see. This is Karimganj division. 70, my lord. There are 4 persons from Kalachi to grade 3 post, my lord, UW assistant.
Okay, similar persons have been promoted that you've
Yes,
shown me. Now, thing is that, where's that vacancy?
Vacancy, lordship will see, lordship kindly turn back to my rate petition, my notes,
Page?
lordship. Page, it took him 33. Operative part, page 34. Serial number 3. Pump operator, the executive engineer informed that there are 18 number of sanctioned posts in the cadre of pump operator. 10 number of posts are filled up at present, leaving vacancy of 8 posts in the cadre. Thereafter, the committee is decided to fill up 8 numbers of vacant posts in the cadre of pump operator. The committee consulted the gradation list of grade 4 employee and found that Fulchan Ali, serial number 5, so-and-so retired, applied for VRS by letter number so-and-so. Hence, his case has been dropped. Thereafter, taking account of working experience in the roster, point, integrity certificate and service record, selected the following incumbent to be promoted to the post of pump operator. And my name appears at serial number 6. Dilip Sharma, Khalasi, unreserved.
You were recommended.
Yes, madam. Then my lord will see, lordship will see page 36. In
Yes.
inviting to the reference to the subject cited, it is to be informed you, the personnel posts are not governed by any service rule, executive order. So promotion from the personnel post to any higher post is not entitled. In this connection, a letter dated issued to all the concerned by this personnel be so and so. Letter number 11722 dated 2/6/22. Hence, your proposal is returned back for your needful action to ascertain the status of the post accepted by the incumbents. Exclude the name of those holding personnel post. They have issued this impugn order. Then, my lord, what happened? Similarly circumstances in other department approached the honorable court, my lord. Honorable court passed order. Lordship for a random sake, my lord, page 44 be seen, my lord. One of the judgment, my lord, which my learned friend has relied, my lord. But this case, those who are appointed Page 44, my lord, second paragraph. Dilip Kumar Talukdar and 21 others. If you go through this judgment, my lord, JLT there, lordship will see all the appointees were made 2005. The regulation has been done 2005. তো আছে নাকি কিতাবটা কোথায়? They are intending to rely on that judgment. But this judgment says something different in para 3. The persons have been incumbent have been appointed year 2005. For them, it is the personal post. So, my lord, I am entitled and my name has been duly recommended by the district level committee, my lord. And law is silent, my lord, where is the needed necessary for sending approval? To that effect, my lord, departmental affidavit is totally silent.
No, what do you understand by this page 44?
44, my lord, it is not applicable in my case. Because I got the judgment. It says about, my lord, those who are appointed on 22/8/2005. Their case was been considered by the division, not my case. Or like similarly,
20, what do you say?
their appointment was 22/8/2005.
So,
Their case was considered by the division bench, the judgment which has been relied by the Dilip Talukdar.
no, what's different about them?
My lord, it is, I don't know why it has been there relied by the department. And if the judgment, it says, my lord, if your lordship kindly permit me, my lord, I have given the, I brought the book, my lord. Lordship kindly have a look, the marking position. It cannot be correlate with my case. And my case is already sanctioned post. And the affidavit which I have shown, my lord, it says about the promotion at the time of my regularization. তুমি কি জানবে না? তাও না কমন বাবা, সাবলে ইমান ফং কে করি একটা বিয়া। তো পুকুর থেকে ফুল টু আনিছে। নাম্বারটা লিখে আছে 5579। এটা কি ডিভিশন? এপিলট আছে। এ মোর মানু রিটায়ার্ডে হবো। Dilip Talukdar. লিখে যা। Being agreed the read petition number 4, 2014, and then thereafter filed an appeal. Dilip Talukdar, State of Assam, the division bench dismissed the appeal on the ground that the claim of the holding acts cannot not. We have other reasons. In view of the present case is covered in terms of Dilip Kumar judgment.
You're stressing on the part that the post will be abolished once the incumbent
Is
either
promoted, retired or died.
just listen,
My lord,
either expires
my lord,
or got promoted or retires.
my lord.
Now, in this particular case of Dilip Talukdar,
It is not applicable in my case.
it
cannot-
says, just listen, please.
My lord, I have gone. through.
If you keep on interrupting,
Lordship, lordship,
how do you proceed?
lordship.
I have to understand your
Lordship,
case,
lordship.
isn't it? Now, in Dilip Talukdar's case, it says that incumbent relinquish the post in any manner. This is a wider thing.
My lord,
In any manner, they relinquish the post.
my lord.
In your case, it is either he dies or gets promoted or retires,
My lord,
limited to 3 factors.
my lord.
In this case, it says that it relinquishes the post in any manner.
my lord. And this,
So how do you say it doesn't cover your case?
my lord, Dilip Kumar Talukdar case was, appointment was made 2005. There is a two segments of appointment, my lord, as like item number 4. That may lead, my lord. So for item 5 to 8, my lord, all appointees were, my lord, regularized 2003. And prior to that, I have been appointed.
2003.
Yes, my lord. Prior to. I have been appointed, lordship has seen, my lord, gradation list who went appointed when.
Now, where's that 2005?
2005, lordship will see the para.
To
three most
draw-
probably. Most
to s-
probably para 3, my lord. Guilty none. Kali phone করলো দিতে গো।
See, you don't dispute the fact that the posts are personal.
My lord, my post,
Your post is also personal.
not personal. So far notification is concerned, which I have shown at page 66, my lord, that cannot be applicable in my case. So far item 5 to 8. And I have been
No,
told,
page 66.
my lord,
This is a part of this is affidavit of reply
reply,
filed by the petitioner.
my lord, when the matter was listed, my lord, I got the copy. Then, my lord, honorable court directed me to file the affidavit.
See, initially you were appointed before 1993
My lord,
on work charge basis.
yes, my appointment was, lordship will see at page 27.
And subsequently,
My lord.
the post was created by this page 66.
My lord,
Then you were appointed and regularized.
Right.
Isn't it?
and as on date, my lord, I am getting my increment also.
Maybe. These regular posts are created by name
Yes,
against each work charge employees.
my lord.
So this indicates that the posts are personal.
This regular post was created by the against name,
Hmm.
and these posts will get abolished automatically as and when concerned employee is retired, promoted, or died. In other words, no appointment will be made against the so-and-so. But promotional skip is there, my lord.
No, promoted word is there. That's why you're stressing on that word
Yes,
promoted.
yes,
Because of that word promoted,
yes.
My
Had it
case-
been not there, my lord, I would have not filed affidavit. also.
but in the other case, 2005, it says that it relinquishes the post in any manner. It's much wider. It may be promotion, it may be by death, or it may be by retirement.
Right.
It covers everything.
My lord, but appointment of 2005 onwards. Only that point. And in the meantime, my learned friend has told me, my lord, same subject matter, appeal is going on before division bench. Just now he told me,
Appeal is going on before.
division bench.
This issue
Appeal
was
number.
decided by the single judge.
Personal post.
No, no,
Yes, Lordship, for PHA department.
no, no, there is a two segment, my lord. One is 2003 and 2005.
The case was dismissed, Lordship.
Only difference is the year.
Yeah.
Only
Because
the year is different.
Yes. ma'am.
Otherwise,
is
the
very
conditions are
different,
same.
Yeah, no, not as the same. 2005, my lord, there is some other notification also there. That will be covered. But instant case, my lord, we are regularized by order 2003. Appeal number to
In view of the present case being covered case in terms of Dilip Talukdar, petitioners are holding ex-cadre post cannot be considered for promotion grade 3 post. So it was dismissed.
Thereafter, appeal, my lord, but
Appeal.
this case, my
Appeal
lord, so
pending,
far,
Lordship.
I got the instruction, my lord, this is not similarly situated person standing like me. Because, my lord, my notification covered by this. And their notification is covered by 2005 as reflected in para 3 of.
You are 2003, they are 2005.
Yes,
Year is different.
only year is different.
But only year is different.
Year is
Everything
different.
same otherwise.
Otherwise, same, my lord, but in that case, 2005, there is no word for promotion. There is no scope for
No,
promotion.
don't get carried away with the word promoted.
My lord, similarly situated given promotion. appeal number two paisa.
Hmm.
Yes,
Number two. Read April 5 of 2024.
five,
5 of 2024.
5 of 24.
See, it is not just the year which is different. It is only the year which is different.
Not only
Otherwise, the
year, my lord.
conditions are same.
No, my lord, maybe the condition, but their service condition does not reflect, my lord. They are not entitled for the promotion, my lord. Dilip Kumar Talukdar case, those who are appointees of that year. But so far 2003, there is a promotion scope, my lord, government has done for other employees, all, not only Kokrajhar, other divisions also.
How do you connect this other appointees which you have just referred to here?
Referred to here, my lord, I just
Do
referred.
you have their appointment orders
No, my lord.
before
only this-
promotion?
Only this copy we.
Then how do you say that they are similar also with me?
Yes, my lord,
like you?
from the year, my lord, it seems government can apprise, my lord, department can apprise.
No, you have to make out your case, you see.
Yes, I made it my case, my lord, because my appointment and their appointment seems to be similar. But I do not have the copy of that person's promotion order. I'll try my level best, my lord, to collect it. And in the meantime, what happens to the rate appeal? That will lead, my lord. Rate appeal number
Yeah.
4,
5 of 2024.
5.
So we'll adjourn it then.
Yes, my
Let
lord.
the appeal be decided.
My lord. And in the meantime, my lord, some of the person will retire, my lord. My petitioner, some of them will retire.
When are they going to retire?
Some, my lord, 3 months, 4 months. Within 4 months, they will retire.
Lordship, that judgment has not been stayed, so it is operating, Lordship. Notice has been issued, but no stay on that single judgment.
And let him apprise by way of filing affidavit, my lord. Their appointment and my appointment is the similar standing. Just bringing a copy, a person belonging to 2005 does not correlate with my case. Itu appointment copy hai.
2003, 4.
3-4. Now, April 2. Better to wait for some time, my lord. ये केस नंबर तो लिखिए सर, कीमत नंबर, WPC कीमत,
Please write down. Heard Mr. J.I. Borbuya, learned counsel for the petitioners. And Mr. I. Bor Thakur, learned standing counsel,
PH, Lordship.
PHE department. By filing these writ petitions, these THES here, these writ petitions, the petitioners claim promotion to grade 3 post. So the case of the respondents, on the other hand, is that the petitioners are holding personal posts and they are not eligible to be considered for promotion against posts. No, eligible to be considered for promotion, since the post they are holding is ex-cadre post. Stop. Mr. I. Bor Thakur, learned counsel, has produced a copy of the order dated 22/9/2023, passed by coordinate bench of this court in WPC number 5579/2023, wherein similar claims made by the petitioners therein was rejected.
now my lord, appeal is pending.
By relying upon the case of Dilip Talukdar and others versus State of Assam and others. 2017, 2 GLT 135. Stop. The learned counsel for the PHED submits that aggrieved, the petitioner has filed a writ appeal, namely writ appeal number
5 of 2024.
5 of 2024. But there is no stay. of the learned single judge order. Stop. He therefore submits that the outcome of the writ appeal may be he submits that therefore the case of the present petitioners are covered by the judgment rendered by the coordinate bench of this court. Stop. Mr. J.I. Borbuhan, learned counsel for the petitioners, submits that the outcome of the writ appeal may be awaited. In view of above, the matter stands adjourned for 3 weeks.
4 weeks, my lord.
For 4 weeks.
Obliged.
Obliged.
Yes.
From the last date, Lordship, wanted instructions from the authorities regarding creation of post of the regular post. So the BTC will provide that instruction, my lord.
Who's the counsel?
May it please your lordship, my lords.
Who's the counsel? Who's the counsel?
B. Chaudhary, he was here only.
B. Chaudhary. You get him? We'll take it up after some time.
Lordship,
My lord, BTC counsel is on his way, my lord. BTC counsel, Mr. B. Chaudhary, is on his way, my lord.
He's on his way.
Yeah, my
After some time, we'll let him come.
lord.
None appears for the parties when the matter is called. List the matter again on Tuesday, huh?
I don't know.
Huh?
I don't know.
14. Okay, cancel the order. Who's the government counsel? Where's he gone?
Basically, the writ petitioner is praying for revocation of his suspension, my lord. Because as per the Honorable Supreme Court's direction in Ajay Chaudhary, it has to be reviewed even after submission of memorandum of charges. And the government of Assam has also issued a notification, which also, my lord, endorses the same view of the Honorable Supreme Court. And my prayer before this Honorable Court was that since no review has been, not even a single review has been done, even after submission of memorandum of charges, I was praying for revocation of my suspension.
My lords, the records have come on the way. But before this thing escalates further, my lords, I will have to admit one thing, my lord. Deputy Secretary, while communicating that order to me, my lord, inadvertently, my lord, they thought that preliminary inquiry or that preliminary inquiry was the report of the final inquiry report. There was misconception on their part. I'll apologize on their part, my lord. So, and other further records reveal, my lords, that part is admitted, my lord. That communication was just sent to us, my lords. It was under the mistaken, my lord, that because when I also went to the report, now there is a communication. The authorities are asking the discipline authority to send the report
If my lord, if it was the first instance, if that report was final, how come you asking the report again and again? Send us the report. That very letter, my lords, it was under the, my lords, misconception or my lords, that my lord, that part is admitted, my lords. Now, my lord, however, whatever, my lord, they have challenged the suspension, but now at this passage of time, my lord, DP was never under challenge. Now this DP has proceeded. And the person concerned, my lord, the delinquent has also entered appearance, shown cause, my lord. Now it's in the stage of final hearing, my lord.
Your basic case was to
Revoke
Uh,
the suspension, my lord.
revoke the suspension
My lord,
order.
if I'll pray, my lord, without going into those things, my lord, since I have admitted, my lord, if the court is inclined, my lord, they can revoke the suspension, but the one thing has to be taken care of, my lord, that situation, that now, since the DP was not under challenge, my lord, the DP has proceeded, my lord. He has to bear those consequences, my lord.
No, DP will go,
Yes.
I mean, DP will go on. What
Yes,
is there?
Yes.
He has not challenged the DP.
He has not challenged.
Why should I challenge the DP? I will challenge the outcome of the DP, my lord.
No,
If the situation arises, my lord.
No, there was also no whisper because the petitioner also, he was all along aware that he was being show cause, he was being show cause, everything was good. He was also aware, man. But that thing also not revealed. But let us not go into that, man. These two communications don't tally, man. That is the issue. That page 14 of the IA, man, that 10, it is at that point it was not there, man. Now only it is reached it. At 22:7, it was not at that stage, man. But Lordship may allow the writ petition if that.
Where's the writ petition? Where's here?
I didn't come here, man.
The main writ petition was for challenging the suspension, isn't it?
Yes, most of it.
But my lord, I'll dispute that, that last time, my lord, on the last occasion, there was a argument from the petitioner's side that because I showed that instruction, the court didn't give him a favorable order. I mean, that is disputed, my lord, because we left everything to the court. We didn't resist anything.
Exactly,
Yes.
that is what my submission is,
Yes,
that
sir.
when you say that
That
DP
is
is in the
disputed.
final stage, why should court interfere with the suspension order? That is why I did not get the interim order, that is my submission.
Your challenge is regarding suspension.
Yes, sir.
My suspension.
And that suspension had subsisted without review.
Without review, as in violation of Ajay Chaudhary and in violation of the OM dated 4/2/2020.
Where's the order? Page 28.
Yes, my suspension order, Lordship. can
No,
find-
that's the charge.
Suspension order is at my lord, page 26, and the so-called notice starts at page 28. 26 is the impugned suspension order.
Suspension of petition.
22 to 2024.
Suspension is at page 26.
Yes, my lord.
no,
Suspension order is 18/1/2024.
18-1.
18/1/2024.
This is the only order regarding suspension.
He was show caused.
No, no, regarding suspension.
Suspension only one. order.
Only one.
No review, nothing.
There was no review.
No review. That is my case.
Well, the Ajay Chaudhary's case, well, the para 27, if a person is also served with a memo of charges, my lord, or show cause, my lord, within 3 months, my lord. It was within 3 months.
Even after 3 months, yeah, within 3 months, even if you give the charge, what happens to the suspension? automatically it will, should it run?
My lord.
Keep on running like that?
No, there should be a reason for
Or
basically.
shouldn't you pass an order saying that although we have given the charge,
Mhm.
the suspension period is about to 3 months now, but because of these reasons, he needs to be kept further
Right.
on suspension. That has to be passed.
That is just a query, my lord. It's my query. It's not my submission. Because my lord, in Ajay Chaudhary's case, what I read, my lord, that person, though it's a case in Ajay Chaudhary, people are getting relief, relying on Ajay Chaudhary. Ajay Chaudhary didn't get the relief because he was charge sheeted.
Where's Ajay Chaudhary? You have the judgment somewhere?
Yes, my lord. I have given last.
Oh, it's here, it's here. Yes, heard Mr. J. Patwari, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the notification dated 18/1/2024, bracket annexure 3, by which the petitioner has been placed under suspension. With effect from 15/12/2023 until further orders. To stop, the learned counsel submits that although a show cause notice was issued to the petitioner on 22/2/2024, bracket annexure 4, by which
DP was initiated.
the charge was framed and the departmental proceeding was initiated. But the suspension of the petitioner has not been reviewed in terms of the law laid down by the Apex Court in Ajay Kumar Chaudhary versus Union of India and another 2015 7 SEC 291. To stop, he therefore submits that the respondents may be directed to reinstate the petitioner. Mr.
D. Gogoi, my lord.
D. Gogoi, learned standing counsel, PhD department, PhD department, submits that the
ভুল করলে ডেপুটি সেক্রেটারি ডেপুটি সেক্রেটারি
although the suspension of the petitioner has not been reviewed within 3 months' time in terms of the Apex Court decision in Ajay Chaudhary, Supra, but departmental proceedings have been initiated against the petitioner within 3 months' time by issuing him show cause notice and the charges and the memorandum of charge on 22/2/2024. And therefore, the petitioner cannot be said to have any grievance. Mr. Patwari, what is the relevant para in the,
21, my lord. Ajay
sorry?
Para 21 of Ajay Chaudhary.
Uh,
May I read it, my lord?
I have heard the submissions made by the learned counsels for the rival parties. Stop, the issue which requires consideration is as to whether drawing of departmental proceedings within the 3 months period of suspension would suffice to keep the petitioner, to keep the delinquent officer under further suspension without a review of the suspension. Stop in this regard, paragraph 21 of Ajay Kumar Chaudhary, Supra may be abstracted. A to A, huh? Red flag.
My lord, may also reflect the OM, my lord, that there is a page 16 of the I.
From the above abstract, it may be seen that the currency of a suspension order should not extend beyond 3 months. And even if within this period, memorandum of charge / charge is served, a reason order has to be passed for extension of the suspension, which otherwise admittedly is not done in the present case. You are referring to paragraph?
Page 16 of the I, my lord. Fourth and fifth paragraph from the top.
This is not a part of the writ petition, isn't it?
I'll interfere, my lord. I'm sorry, my lord. I've been summoned at court 5 minutes.
Sure.
This is not that I, my lord, I have brought in.
This will be a submission.
Because it's a mandatory, my lord. Paragraph 4, lordship, from the top, lordship kindly peruse. After issuance of the office memorandum of charge sheet, the senior most secretary shall undertake a review within 6 months.
It's okay, Mr. Patwari. Next para. At this stage, Mr. J. Patwari, learned counsel for the petitioner, has also drawn the attention of this court to the office memorandum dated 4/2/2020, issued by the Government of Assam in the Department of Personnel, personnel within bracket B, under memo number ABP stop 13/2018/PT, P for Punjab, PT/35, wherein in line with the decision of the apex court in Ajay Kumar Chaudhary, Supra, as well as a direction of this court dated 30/11/2017 in WPC number 6465/2017. It has been provided that after the issuance of memorandum of charge / charge sheet, the senior most secretaries shall undertake a review within 6 months as regards the desirability to further continue with the suspension order. Further, the senior most secretaries will be held responsible if cases of suspension in the respective departments are not dealt with and reviewed accordingly. The learned counsel submits that even on this count, the impugned suspension of the the suspension of the petitioner without a review it cannot be sustained and should be interfered with by this court to stop. The petitioner, as can be seen, has been suspended since 15/12/2023, and in the absence of any review made by the competent authority in terms of the decision of the Apex Court as referred to herein above, the same shall not be sustainable. No, the same cannot continue in perpetuity. So accordingly, the respondents are directed to reinstate the petitioner. Back into service.
Within a specific time frame, my lord.
What could be the time frame?
Maybe already, my lord, I've been suffering, my lord. So if at least within 2 weeks or something like that, will help the cause of the petition.
Why should we give 2 weeks immediately?
Immediate. I have applied.
To be reinstated immediately.
And lordship has-
However, it is observed herein that since the departmental proceedings has been initiated against the petitioner, the same should be brought to its logical conclusion as expeditiously as possible. It is also made clear that if the subsistence allowance you have received,
It's received.
okay. Any other observation required?
My lord, perhaps one observation that suspension order has to be set aside and quashed. That line has to be there.
It is needless to state herein that the suspension, the notification dated suspending the petitioner is hereby set aside.
And deeply.
Then in view of the order passed in the amended petition, the IA stands disposed of.
Much obliged, your lordship.
Immediately. Not within.
Time being 9 to 13.
What item?
May it please your lordship. May I have your lordship's permission to address your lordships through the virtual mode? May it please your lordship.
Lordship,
What is the status?
Lordship, the post is yet to be created. The proposal is on. And the approval from the higher authority, that is the government, is yet to receive. Yet to be received, Lordship.
How long will you wait? Should we wait for that?
Lordship, creation of post. Since it's not a sanction, Lordship, lots of factors are there. And Lordship,
School was initially what, high school?
yes.
It has been made as a high secondary school now. And for that reason, now the headmaster has become principal.
Yes.
There is no post of principal.
There was a post of headmaster that was subsequently abolished due to provincialization of the school to higher secondary.
Correct. So against the
Yes,
Instead of
sir.
abolishing it, you could have upgraded that post also.
Exactly, my lord. Since the post has been abolished, that can be done, my lord.
Because see, a lot of difficulties have been faced by everyone. Parties are battling they're having this dispute over who will take charge, review, writ petitions. It's going on and on. Now, if you create the post, or if you upgrade the post of the headmaster to principal, matter ends. Whoever is eligible will be considered and appointed.
Earlier, for whatever reason, the authority thought it best, they abolished the post of headmaster.
Hmm.
Now, since the principal is required and the post is not there, it has to be created, and accordingly, the proposal has been moved long
Where
time back.
where is the proposal? Can you show me?
Lordship, at this, I just had verbal conversation, Lordship, that document I do not have, that I can show.
You get the document. You give the
Lordship,
proposal.
It has to come from the BTC area, Lordship.
It may come. You let them send by WhatsApp and get it printed. Give me a copy. We'll speed up the matter
Yes, Lordship, that can.
because they're not taking interest because this has been pending for a long time.
Perhaps that is the reason, lordship, while vacating the interim order, the writ petitions were not closed because I was there, my lord. That if the matter is disposed of like that, then post will kept pending. That is the reason. Lordship modified the interim order and the matter was kept open, my lord, on the last occasion. The order which they have sought review, my lord. In fact,
That's
Will you
IFPF.
produce it tomorrow.
Yes.
Mr. B. Chaudhary, learned counsel for the BTC, submits that he will produce the process of creation of the post of principal. Which school is this?
Dakshin Bizni Adarsh Vidyapith High School.
For Dakshin Bijni Adarsha Vidyapith
Right.
High Secondary School
That has become higher secondary school.
by tomorrow. This again tomorrow. You will get the name, huh? Here, page 4. Red flag, page 4.
Yes, Lordship. I filed the affidavit in reply as well as the IA yesterday, madam. Possibly it's not on record, Your Lordship.
31. What IA you filed?
Malad, IA for correction of the name of the respondent number 4, Malad. In the last order, Malad, Your Lordship has directed us to file an IA regarding correction of the name.
Okay.
IA to
What to do?
The IA has not been listed and the affidavit in reply also they have filed, that has also is not on record, Your Lordship. They did come after a short date because there is urgency from our side also. Also, they did come after a short date, Your Lordship, some fixed date and a short date, Malad.
The rejoinder affidavit filed by the petitioner as well as the interlocutory application for correction of
The name of the respondent number 4, Malad.
name of respondent number
4.
4. Is not on record and has not been listed today. Office to verify and list the matter again. When? Wednesday?
Lordship.
On Wednesday next. Please give the date.
No, no, एक मिनट है, अभी 12 थोड़ा ही होगा 18th और
Break 5 minutes, okay? I'll come back in 5 minutes. Shall continue. You were there, okay, please add it, okay. Have you flagged it?
Yes, my lord, kindly see orange color flag. Flag A. Orange
A1.
color, Orange A
A,
is
Hmm.
that is the list of selected candidate.
yes,
And in flag A1, here the in serial number 201, flag A1.
Hmm. Serial number
209.
209.
That is the respondent number 7. Naresh Singh.
Hmm. Yes. Narendra Singh.
Yes, he got 67 marks
Hmm.
in all over written test.
Hmm. Written test,
Yes, 67.
including the typing test also.
No, that is only for written test.
Only
I'm
for
coming
written.
to that man.
Okay,
67 marks, 67.
yes.
Now, my lord, kindly come to the flag number B.
Hmm. Yes. Serial
Serial
number,
number 156 to 160. Those are the candidate for Uttarakhand.
serial number,
156 to 160. 4 candidate of the Uttarakhand. One of the candidate is the petitioner. 156, 157, 158, 159, 160. Flag B.
Hmm. So where's the petitioner?
Petitioner is my lord.
What is his name?
Sanjay Singh Ganguly,
157.
157. He got 55 marks.
Hmm.
And
Then,
not selected for low merit.
Hmm.
That in remarks column, last one. Remark column,
low in merit.
no in merit. Now, my lord, kindly come to flag number C.
So what about the respondent number 7?
Respondent number 7, my lord, is in flag number A1209. Serial number 209, flag number A1.
Oh, we have already seen that, isn't it?
Yes, huh?
Hmm. Yes, then,
Now, my lord, come to flag C.
yes.
Flag C. That is relaxation in trade test. One.
Sorry,
Relaxation in trade test. Flag C.
relaxation in trade test.
Yes. Here, my lord,
What do you mean relaxation?
my lord, kindly see to the flag D, my lord. Flag D, there is a
Hmm.
table, my lord. Flag D.
Hmm. Yes, flag D.
Clause 2, there is a table, my lord. There are total 377 candidates. Only 13 candidates got above 35 marks, my lord. And kindly see that clause 4. That is their decision.
This skill test was done in respect of Uttarakhand only,
No, only for the whole advertisement, not only for Uttarakhand.
as per this flag D.
Yes, yes, flag D, yes,
Hmm.
not only for Uttarakhand.
So what
for
are
all
these
the-
serial number 1, 2, 3, 4, 5, 6?
1, 2, 3, 4, 5. 4 is the decision of the competent authority. Clause
No, no,
4.
no. The Roman numbers.
1, 2, 3, my lord, Roman 1, but the total number of person who got below 20, below 35. 1 to 3, some got below 1 to 20, some can type, some could type 2 to 20 to 30. That's
No, that's okay. But where does the petitioner and the respondent fit in here?
My lord, there is no specific in whether the respondent or petitioners, but the total number who got the above 30, 35, that is total number of candidate is 13, my lord, as per that table. Not only the respondent, my lord, the relaxation has been given to the all candidates. And my lord, kindly see in clause 4, my lord. The relax that 35 to
35 votes and above have been typed only by 13 candidates.
Yes. My lord, kindly read clause 4, my lord.
Hmm. Serial number 4.
Serial number, clause 4. 1, 2, 3, 4, there are some clause, my lord. 1, 2 is the table, 3, 4.
Yes, 4.
Yes. My lord, there is some decision of the competent authority. Not in table, my lord, clause 4.
Yes, I've seen that.
Yes, ma'am. They relaxed that the 35 marks to 20 marks. Because the reason has been stated in the clause 4.
What does this clause 4 mean otherwise?
My lord, they have the power to relax that relax that trade test. What is that the marks of the trade test, my lord. And because my lord, only 13 candidates got above 35, could type the 35. That's why they took the decision to, because and they decided to that marks up to 20. They came down to 20, my lord. Clause 4, as per clause 4. And that is not only for Uttarakhand, for the whole state, for all over India. For all the states.
What is DME? Medical.
Medical, detailed medical examination.
So relaxation is not in clause 4, clause 5.
Sorry, my lord, clause 5. Yeah.
4 is regarding saying that only
DME.
13 candidates have managed to type 35 words.
Yes, ma'am. And then
So number 5, clause 5 says that now they have decided to
yes,
scale down to 20 words per minute.
20 words.
Now 20 words per minute means 61 candidates.
Yes, my lord. Not only respond number 7, that everybody got opportunity.
Now, what about the petitioner?
Petitioner is he is in above 35. My lord, kindly now see that page number flag E, my lord.
You don't have the records of the typing results.
Don't have the record my typing.
Then how do we decide?
But kindly see flag E, my lord.
Flag E.
Flag E. That is the advertisement.
Where's flag E?
Flag E.
D.
E.
Okay, E, yes.
Now, clause 17, trade and skill test. Trade test for technical tradesmen and personnel, including the clerk and personnel, will be conducted before undergoing detailed medical examination. No marks will be awarded. Candidate will be assessed as a pass or fail. Candidate who pass the trade test will only undergo the detailed medical examination. Now, clause 19. The candidate who qualified in all aspects, that is physical standard test, physical efficiency, written test, trade test, medical exam, will placed in the merit list depending upon the trade category wise vacancies allocation on the state, and the instruction to join the training center for enrollment will be issued on the basis of merit list. Please note that merely qualifying in all tests does not confirm that candidate will be appointed. My lord, on merit list, he did not selected because he is the low in the merit list, my lord. He may pass that, my
No,
lord.
low in the merit list means what was the marks obtained by him?
In merit list in flag A, flag B, my lord. A1, my lord, that is the petitioners, not that flag B is my lord respondent, private respondent, 209. In merit list, he got 67.
What is the name of the petitioner?
Petitioner Sanjay Singh Gangola,
He's got 55.
no, 67.
Sanjay Singh Gangola.
Sanjay Singh Gangola. Sorry, Sanjay Singh Gangola, 55, yes.
55.
Yes, Narendra Singh got 67. Narendra Singh in A1. Serial number 209.
How much is the vacancy
How many
for
vacancies?
Uttarakhand?
Only one vacancy.
Only one vacancy.
Only one vacancy.
The lordship, they themselves have admitted that the respondent was not able to type the 35 words. Now, can they arbitrarily relax the advertisement?
See, what they say is that out of the candidates, total candidates, only 13 persons,
I
13, 1-3.
I was one of them, 13. I was one of them in that 13.
Just a
So
minute.
how can they say that I'm in low in merit?
Just
if
a
I
minute.
pass all the
Just a minute. Out of the total candidates who went for the typing test, only 13, 1-3 candidates could type out 35 words per minute, maybe including the petitioner. Okay. Respondent number 7 could not do it. But what they've done is that this much of vacancy is there. If we only take 35 people, 13 people, then what will happen? So they say that we'll scale down the marks, the words per minute to 20 words per minute. So when they scale down to 20 words per minute, a few 60 plus candidates have come into the picture.
Lordship,
And the typing test does not carry marks as per the
no,
advertisement.
it does not carry marks. But
It
there
does
are-
not carry mark.
But
Okay.
there are some criteria
is-
that you have to pass that exam.
It is pass or fail. That's all.
But you will have to pass it.
Hmm.
Then only you will be eligible for sitting in DME, detailed medical examination. Without passing the examination of trade test, skill test,
They have passed.
they have not passed. Your
They
lordship,
passed.
he was not able to type 35 words. Arbitrarily,
He is
in
not the only one.
Same day,
He is not the only one. There's all of them,
then maybe.
except for 13 people.
Maybe, but your lordship, on the same day, can they do arbitrarily relax the norms of the advertisement? Is it permissible, your lordship? I leave it to your lordship.
Hmm.
I cleared my physical test examination. I appeared in written examination. I cleared skill test and medical examination.
Hmm.
And why my candidate is rejected? Saying you are low in merit. How can I be low in merit? As per the advertisement, I have typed 35 words. Then how can I be low in merit?
Now this 67 marks is in written
Yes.
examination. Is it
Yes, your lord.
given to the respondent number 7 or the what you call 55 marks to the petitioner? How is this marks given? Ms. Gayan,
My lord, that is in the written examination. There was a written examination, my lord.
where's the evaluation?
Evaluation, I don't have. I have to collect the evaluation. Written examination, I can collect.
Yeah, you have to give the evaluation.
Yes, my lord.
What do you mean by 55 marks? And what do you mean by 67 marks?
Yes.
How you have given these marks?
Then I have to produce the record of my lord. Evaluation paper.
Ah. But these marks are not regarding that skill test.
Not skill test.
Skill test is only
Skill
pass
test
or
is
fail.
only Pass or fail, man.
Hmm.
That is as per advertisement in clause 17, that is specifically stated that there will be no mark for skill test, only pass or fail. That is
Wha-
in.
Have you filed your affidavit in opposition?
Yes, I have. filed
What
it.
is your stand?
That is stand on.
Have you indicated about the relaxation of this
No, Your
typing test?
They have remained silent.
My lord, in page 9, paragraph 22.
Just a minute, huh? Hmm. From the records, where's the advertisement?
Record, my lord, advertisement in annexed E. Sorry, flag E.
Flag E, you have shown
Flag
me.
E.
Regarding that 35 words per minute, where's that?
That is. Just a minute.
Hmm.
Page 26 of the writ petition.
Please write down. Being unsuccessful in the selection process for the post of Havildar clerk in the Assam Rifles, the petitioner has filed the instant writ petition, claiming that although the respondent number 7 could not clear the typing test by typing 35 words per minute as was required in terms of the advertisement, he has been selected for the post. Stop. The petitioner otherwise has claimed that he could type out the required number of words in the typing test. Next para, Ms. A. Gayan, learned CGC, has produced the relevant records and submits that only 13 candidates could type out 35 or more words per minute. And so the competent authority decided to accept those who could type 20 words per minute to qualify for the, what do you call it, medical test? That some terminology is there.
Detailed medical
Detailed medical examination.
DME.
DME.
Qualify for the detailed medical examination, bracket DME. Stop. She also submits that the petitioner was low on merit, having scored only 55 marks compared to 67 marks scored by the respondent number 7. Stop. Next para. Upon being asked as to how the assessment, how the marks have been given as shown in the merit list. Since the details are not in the record produced today, the learned CGC submits that she may be given some time to produce the same before the court. But these are the records. What else would you have?
My lord was asking about that,
Marks.
marks.
How you have given 55 marks? How you have given 67 marks?
On written exam, there was a written examination, my lord, there was an evaluation sheet, my lord, on that, I think.
In view of above, the matter stands adjourned to enable the CGC produce the evaluation sheets in respect of the petitioner and the respondent number 7 by the next date. List the matter again. 1.
After vacation, my lord.
This will come from
Because
where?
17, my lord, the recruitment, and we have to collect from Nagaland, my lord.
Okay.
And 2017, well, very old, that's sure.
We'll have a date.
Yes, ma'am. First week of November, ma'am. 5th of November.
I think that's too far away. Why not last week
Last week, yes, ma'am. Last week,
on 29th of
yes, ma'am.
October?
Much obliged.
Please take back the records, okay? This is item 1, na? What? 1. Okay. Yes. You are for the respondent?
Lordship, yes.
What is the matter about? Huh? Yes, what is your submission?
Lordship, my senior is in legs in the report.
Who's your senior?
Dinath.
Sorry?
Dinath.
D. Nath. He's
Lordship,
appearing
matter-
for which
matter
respondent?
of-
Who's the counsel for the petitioner? None appears for the petitioner when the matter is called. Matter stands dismissed for default. Interim order passed earlier, if any, stands vacated. Yes.
Well, here petitioner was initially appointed as a cleaner, my lord, in PHC department on 1/5/1993. And since then, he has been working.
What is your claim?
My lord, claim is, my lord, for regularization, my lord. There
Let
was,
vote.
my lord, a similarly situated person. I have implemented all the respondents, my lord. Those respondents were appointed later than me, much later than me. The service of all of them were regularized, my lord, in between, my lord.
No,
I have submitted the RTI application,
petitioner is working as what?
matlab, as cleaner,
Dina, where?
yes, matlab, PHC department,
PHE.
as a casual worker, matlab. Admittedly, matlab,
Since when?
1/5/1993, matlab. Prior to-
1593.
Yes. My lord, till 1493, my lord, all the persons, as a my lord, one policy decision, government has regularized service of all the casual workers up to 1/4/1993. So my appointment, my lord, later than that, 1 month later than that.
So there's no point in going back to that 1/4.
Yes, my lord. I am not on that. I am, my lord, on that. The similarly situated persons, my lord, I have annexed all the my lord, RTI reply provided to me. My lord, that respondents.
You are still on casual basis as
Yes,
on
my lord.
today,
Yes, my lord.
under PhD.
Yes, my lord. So, my lord, as on today, I have, dear my lord, serving there almost my lord, 31 years. But my service has not been regularized. But other persons who were engaged my lord, in the year 2004, 2006, 2010, their service has been regularized in the year 2014 itself. I have annexed lordship, my lordship may kindly come to the annexers, my lord.
What do you say about that case?
Well, they have filed their affidavit, my lord. Respondents has, civil engineer has filed their affidavit. They have categorically admitted, my lord, admitted the position of the present petitioner. They have not denied,
What about Upendas?
my lord.
Upendas case.
Upenda's case is, my lord, letter to the petitioner, that is, my lord,
It may be
letter-
later, but it clearly lays down that no more regularization.
Even then, my lord, in Upenda's case, my lord, no more regularization, but my lord, considering his length of service, my lord, the remuneration and the other benefits, my lord, equal to the, my lord, the regular.
Remuneration is a different thing.
Yes.
Regularization is another different thing again.
And this case, my lord, the petitioner approached this honorable court in the year 2015. Therefore, it was case for listed for hearing, my lord.
Maybe, but
It was in
can you
part.
carve out an exception?
My lord.
Can you carve out an exception that your case is different? Since 1993, you've been working.
Yes.
So you're not covered by the Upendas.
I am only on that, my lord, that similarly, equals are not treated equally.
Maybe.
Similarly, equals are not treated equally, my lord. Similarly situated person, service of the persons, for some extraneous consideration, their services were regularized and it is admitted by the respondents in the affidavit as well as in the reply to my RTI application. So that is the violation. In the lordship, kindly come, my lord. I have one judgment or latest judgment of Honorable Supreme Court, my lord.
Yes.
My lord, considering the length of service, in that case, my lord, 28 years. Yes, served 28 years, my lord.
Which is the relevant portion?
My lord, sorry, my lord.
You have only one copy.
Yes, my lord, I'm trying, my lord, but in internet.
You
is
take
not
this
working.
copy, you read
My lord.
whatever relevant it is.
Lordship, if I may place recent judgment of this honorable court.
You can read only one judgment at a time. You wait for your turn. Yes.
My lord, page 6, my lord. in this case.
This is also again Upen Das and Uma Devi. That's what I'm asking him.
Yes.
How do you circumvent this Upen Das and Uma Devi?
In this case, my lord, the
You may have been very senior and others similarly situated may have been regularized long time back. But can that be a ground to regularize you today?
that is a violation of Article 21, my lord. Violation of principle of natural justice. In this case also, my lord, the petitioner was appointed in the year 1991. May I read, my lord, relevant portion?
Yes, read.
We have carefully considered the rival consideration advanced at the bar. At the outset, we would like to state that this is a case of gross violation of Article 14 and 16 of the Constitution. The appellant, who has been working in the respondent number 3 municipality since 1991 and was subsequently appointed as a clerk in 1996, has not been regularized in his service. Moreover, several of his co-employees, including juniors, have been regularized in service. The High Court's order dated 26/2000 in writ petition number so and so clearly shows that absorption has been given effect to white order dated 26/9/1996. The said writ petition was dismissed to the extent of entitlement of backdated appointment and arrears. However, the respondents never paid any heed to such order and inordinately delayed the appellant's appointment, while simultaneously absorbing other casual employees. Even the appellant's service book record that respondent number 3 municipality has absorbed the appellant in view of the High Court's order dated 26/2000 in writ petition numbers so and so. The respondent has relied on Uma Devi judgment to contend that there is no fundamental right in those who have been employed on daily wages or temporarily or on contractual basis to claim that they have a right to be absorbed in service. The relevant portion of the factual position in Uma Devi is being reproduced as hereunder. The respondents therein who were temporarily engaged on daily wages in the Commercial Taxes Department in some of the districts of the state of Karnataka claim that they worked in the department based on such engagement for more than 10 years and hence they are entitled to be made permanent employees of the department, entitled to all the benefits of regular employees. They were engaged for the first time in the year 1985-86 and in the teeth of orders not to make such appointments issued on 3/7/1984. Though the Director of Commercial Taxes recommended that they be absorbed, the government did not accede to that recommendation. These respondents thereupon approached the Administrative Tribunal in the year 1997 with their claim. The Administrative Tribunal rejected their claim, finding that they had not made out a right either to get wages equal to that of the other regularly employed or of regularization. Thus, the applications filed were dismissed. The respondents approached the High Court of Karnataka challenging the decision of Administrative Tribunal. It is seen that the High Court, without really coming to grips with the question, falling for decision in the light of the findings of the Administrative Tribunal and the decision of this court, proceeded to order that they are entitled to wages equal to the salary and allowances that are being paid to the regular employees of their cadre in government service with effect from the dates from which they were respectively appointed. It may be noted that this gave retrospective effect to the judgment of the High Court by more than 12 years. The High Court also issued a command to the state to consider their cases for regularization within a period of 4 months from the date of receipt of that order. The High Court seems to have proceeded on this basis that whether they were appointed before 1784, a situation covered by decision of this court in Dharwad District PWD literate daily was so and so, state versus so and the scheme framed pursuant to the direction thereunder, or subsequently since they have worked for a period of 10 years, they were entitled to equal pay for equal work from the very inception of their engagement on daily wages and were also entitled to be considered for regularization of their post. However, in the present case, as we have observed, the appellant was appointed as a casual worker in 1991, while the services of other co-employees were regularized. That of the appellant and some others was left out. The High Court, in its order dated 3/9/2010, passed in writ petition number so and so, has also recorded the respondent's submission that resolutions pertaining to the appellant's absorption are already in place, and the same have been sent for necessary approval. Therefore, the judgment rendered in Umadevi will not apply to the facts and circumstances of the present case. Now coming to the reason order dated 7/3/2012 passed by respondent number 2 herein, which states that in pursuance of the High Court's order dated 24/8/2009 not to give effect to the instruction of the Labor Department pertaining to regularization of casual employees, as communicated in the circulars dated 13/8/1979, 28/8/1980, and 13/3/1996, the appellant service cannot be regularized. However, what is to be seen here that as early as 2002, that is High Court's order dated 26/2000 in writ petition number so and so, clearly shows that absorption has been given effect to void order dated 26/9/96. Moreover, as has been observed above, the respondents had also submitted before the High Court in writ petition number so and so that resolutions pertaining to the appellant's absorptions are already in place and same have been sent for necessary approval. Apart from this, it is evident from the facts and circumstances mentioned above, the non-regularization of the service of the appellant in the present case is, in our view, a violation of the fundamental rights of equality before law and equality of opportunity in matters relating to employment under the state, as enshrined under Article 14 and Article 16(1) of the Constitution, respectively. It is to be noted that the appellant has retired on demand. The facts of UP SEB are similar to the case in hand, and relevant portion of the said judgment is being reproduced hereunder. By means of the writ petition, 34 petitioners who were daily wage employees of the Cooperative Electric Supply Society hereunder referred as the society had prayed for regularization of their services in the UP State Electricity Board, hereunder referred to Electricity Board. It appears that society had been taken over by the Electricity Board on 3/4/1997. A copy of the minutes of the proceeding dated 3/4/97 is annexed P2 to this appeal. That proceeding was presided over by the Minister of Cooperatives, UP government, and there were a large number of senior officers of the state government present in the proceeding. In the said proceeding, it was mentioned that the daily wage employees of the society who are being taken over by the board will start working in the Electricity Board in the same manner and position. Pursuant to the said proceeding, the respondents herein were absorbed in the service of the Electricity Board. Earlier, the Electricity Board had taken a decision on 28/11/1996 to regularize the service of these employees working on daily wage basis from before 4/5/1990 on the existing vacant post, and an examination for selection would be held for that purpose. The contention of the writ petitioner respondents herein was that since the society had been taken over by the Electricity Board, the decision dated 28/11/1996 taken by the Electricity Board with regard to its daily wage employees will also be applicable to the employees of the society who were working from or before 4/5/1990 and whose service stood transferred to the Electricity Board and who were working with the Electricity Board on daily wage basis. The learned single judge in his judgment dated 21/9/1998 held that there was no ground for discriminating between two sets of employees who are daily wagers, namely the original employees of the Electricity Board and the employees of the society who subsequently became the employees of the electricity board when the society was taken over by the electricity board. This view of the learned single judge was upheld by the division bench of this High Court. We are in agreement with the view taken by the division bench and the learned single judge. The writ petitioners who were daily wagers in the service of the society were appointed in the society before 4/5/1990 and their services were taken up before the electricity board in the same manner and position. In our opinion, this would mean that their services in the society cannot be ignored for considering them for the benefit of the other dated so and so. In the present case, many of the writ petitioners have been working from 1985, that is, they have put all about 22 years service, and it will surely not be reasonable if their claim for regularization is denied even after such a long period of service. Hence, apart from discrimination, Article 14 of the Constitution will also be violated on the ground of arbitrariness, unreasonableness, if employees who have put in such a long service are denied the benefit of regularization and are made to face the same selection which fresh recruits have to face. The principle of natural justice too demand that the appellant cannot be denied the benefit of regularization of the services when the similarly placed fellow employees have been granted the said benefit. Therefore, we do not agree with the view taken by the impugned judgment of the High Court as well as by the learned single judge in writ petition number so and so. The appellants herein, in our considered opinion, is entitled to receive back wages and benefits from 1991 along with an interest of rupees at the rate of 10%. Accordingly, the appeal is allowed. The impugned judgment dated so and so, passed in so and so, is hereby set aside, however, the facts and circumstances. So, well, considering the length of service, and similarly, other situated persons, their service has been regularized. The petitioner service.
How that Uma Devi's case has not been made applicable in that case? You were reading which paragraph?
Yes, my lord. Paragraph 23, my lord, of this judgment. I'm again reading, my lord.
No, don't read. See, one thing. You were also saying that department also agrees.
Yes.
Who has filed the affidavit?
No, chief engineer, my lord.
It's not the government.
No.
Chief engineer has only said
Yes,
that
department head.
you have raised the question, why you have regularized this private respondent and
Yes.
leaving me behind.
Yes,
What they say is that we have regularized as per the government approval.
yes,
Only that much.
yes.
Government
They
has
have
not said
ag-
anything. Government has not clarified why they have regularized.
Yes.
So,
Government is yet to file their affidavit.
exactly,
They
there's
have not filed
nothing,
their
there's
affidavit.
nothing there. They're simply saying that it is not us. Government has given approval, so we regularize. Now, what would be the reply of the government? That
The
is not,
government is not
that is
coming
not
to the-
available.
Government is not coming, government is not contesting.
Chief engineer will be the
Department head,
department head who has forwarded.
yes.
This is an application. This is the position. Government may take necessary action.
Yes, executive engineer forwarded my application also, but my application was rejected on the ground that I was appointed later than the 1/4/1993. I was appointed on 1/5/1993, so I will not come under the policy of the government.
You come to your affidavit.
Yes.
Paragraph 5.
Paragraph 5. With
With-
regard to the statements made in paragraph number 4 and 5 of the writ petition, the answering deponent states that in accordance with the government letter dated so and so, Srimati Jayanti South and Buddheswar Borough were appointed against the existing grade 4 vacancies. So, this is, Malad, initially she was appointed as temporarily. Later on their service regularized.
What do you say? You're for the PHE department.
Yes, Lordship,
You appear for the chief engineer
Chief
as well as the state government also.
Yes.
Why they have not filed, state government has not filed affidavit?
Well, Lordship, this was filed long time back, Lordship, when I But Lordship, now what has happened, I have placed a judgment, Lordship. There is a bar on the state government itself to regularize pursuant to Upen Das judgment, Lordship. Even if the state government wants to, it cannot, Lordship, because of the operation of Upen Das. And the judgment, Lordship, that I have placed, Joy Narayan, there the petitioner was appointed even prior to 1993. But his case was rejected, Lordship, because very categorically Upen Das has held that since there are no vacant sanction posts and Uma Devi's exception has not been made out, so therefore they cannot be regularized, Lordship. In state of Assam, Lordship, particularly, there was actually never any sanction posts for muster roll workers. That observation was also given in Upen Das. And in fact, Lordship, those who were regularized in 2003 and 2005, they were also, Lordship, in Jiten Kolita case, it was said that they were also not appointed pursuant to a valid policy, but it was not disturbed. But Upen Das has said that after this point, there shall be no further regularization, Lordship. And the only thing that they can avail is if they are eligible, that fixed wage.
Upen Das was an appeal by the state, isn't it?
Appeal by the state.
Why appeal was filed?
Because a single judge had allowed the prayer for regularization of those workers, Lordship. And then the state government filed an appeal.
The finding in Upen Das case.
May I just summarize? In 2012, Finance Department issued one notification that henceforth there will be no more regularization and there will be no more creation of supernumerary posts. That notification was valid and that was set aside by the learned single judge.
2012.
Against that judgment, this Upen Das appeal was filed by the state, wherein Lordship will find one mention of an missed case, Lordship.
Yes.
It was around 2012, Lordship. Therein, state government sought leave from the Honorable Court for consideration of regularization of the muster roll worker who could not be regularized in the year 2005. Because in the meantime, that Uma Devi judgment came in 2006. And the division bench declined to grant any such leave, Lordship.
Miss case.
In Upen Das judgment, Lordship will find mention of one miss case. Upen Das judgment.
Miss case 597 of 2012.
Yes. Before the division bench, Lordship.
In WPC taken up.
One taken up matter was there because it was as regard the conditions of the inmates who gets food jail. It was our prayer that because of lack of manpower, we are not able to properly function in that institution. And that miscase was filed for seeking leave for consideration of regularization. That was not granted. And that is why, Lordship, 2005 was, 5 batch was the last batch, Lordship, when regularization was made, thereafter no regularization of any muster worker.
The state government itself had given a ban, isn't it?
Yes.
That ban was interfered with by the single judge. Ban was interfered by the single judge. That's why appeal filed. Yes.
Against that order, Upen Das was filed.
What is the salary given to you otherwise?
Yeah, this case, my lord, I don't know, my lord, but earlier, my lord, it's meager, my lord, 900 and something, my lord.
So you'll be entitled to the minimum scale
Yes,
as per this Upen Das only.
yes, and there is another, my lord, full bench judgment after Upen Das of this honorable High Court, my lord.
Which says?
My lord, it says the same thing, my lord. I am reading that Upen Das last paragraph, my lord.
Yes.
It is, however, heartening to learn that the state government has agreed not to terminate the muster roll workers and similarly place the employees working since last more than 10 years, not in sanctioned post, till their till their normal retirement, except on disciplinary ground or on ground of criminal offences. The state government has also agreed to enlist such employees in health and accidental and death insurance scheme, which will be prepared in consultation with the state cabinet. The last paragraph is quoted in this case also. But so far, my lord, if I say, my lord, the last 10 years not in sanction post. Well, a person, my lord, working in a post since last 31 years, can it be, whether it is sanctioned or not, my lord, how it cannot be sanctioned, my lord, how can they say that it is not a sanctioned post? Person is still working.
Whatever it may be, I think we are bound by this, Bhupen Das. That's what I indicated.
My lord.
We'll make an observation. If you're not given the minimum scale, will be given that. With that, we close the matter.
So at this, I have to follow this also because full bench judgment, nobody has challenged this. So at this stage, this is binding on us. That is why.
Exactly. Anyway, we'll come back at 2.
My lord.
Meantime, you also you share a copy of the judgment which you're reading. You just go through that also and just see what is there. Which item? 20. It'll reach. I think it should reach. Who's for the other side?
Government,
Government. You're Mr. Dhar?
Yes.
Okay. We'll see. Mr. Saikia, what do you say? Kalita, sorry.
So, my lord, at this stage, we are, my lord, to my information, my lord, one of my learned friend informed me that Bhupen Das was challenged before the Supreme Court. But what is the my lord, outcome? I don't know. He is also not away. So, at this stage, my lord, we are bound by this Bhupen Das.
So we'll dispose it off in terms
My
of
lord.
heard. It is right down. Heard Mr. N.K. Kalita, learned counsel for the petitioner, and Mr. I. Thakur,
Lordship.
learned counsel for the respondent number. Learned counsel for the PhD department. And who else? Our board Pujari, learned standing counsel, finance department. Correspondent number 2.
Covered, my lord, by Bhupen Das.
By filing this writ petition, the petitioner prays for a direction to the respondent authorities to regularize his service in the Grade 4 post in view of the fact that other similarly situated persons, such as the private respondents, who had in fact entered much later to the petitioner in service, have been regularized. Now, the learned counsel also submits that as per the affidavit of position filed by the respondent number 3, that is the chief engineer, PhD, the same supports the case of the petitioner. As it is stated that the petitioner has been working on casual basis since 1/5/1993. And those and other persons similarly situated have been regularized in terms of the approval given by the state government. Next para. The learned counsels appearing for the respondents, on the other hand, submit that in view of the decision of a division bench of this court in State of Assam versus Upendas, two thousand 17 for GLR 493. There is no scope of regularizing the service of the petitioner. Of the learned counsels submit that the government of Assam had come up with an office memorandum dated 16/6/2012, providing that there will no longer be regularization of muster roll or work charge workers by creating supernumerary posts. Stop the same as, however, interfered with by the learned single judge of this court, but was reversed by the division bench in Upendas Supra. The learned counsels submit that the only benefit which can be given to the petitioner would be only in terms of paragraph number 22 of the judgment of the division bench in Upendas Supra. Next para. Upon hearing the parties and upon perusal of the materials available on record, it only appears that the case of the petitioner is squarely covered by the decision of the division bench of this court in Upendas Supra, and accordingly, no relief can be granted to him insofar as regularization is concerned. Stop. However, if the petitioner has not been receiving the minimum scale of pay in terms of paragraph 22 of the judgment under reference, the same should be given to him by the respondent authorities. That's all.
Lordship, there will be a verification process for the benefits under Upendas. Lordship may.
In order to grant such benefit, the respondents will be at liberty to make necessary verification.
Well, that benefit with effect from?
What would be the effective date?
From the date of judgment of Upendas, Lordship.
Necessary verification, and the benefit, and if the petitioner has not been granted any such benefit, the same should be given to him with effect from
Date of judgment of.
the date of judgment of Upendas Supra. With the above observation direction, writ petition stands disposed of. Yes.
May I please, Lordship? Lordship, this matter relates to the compensation of appointment, Lordship. We have challenged, Lordship, the acquisition of the district level committee.
Page?
District level committee, Lordship, decision is at page, Lordship, 27, Annexure Z.
District level or state level?
District level, Lordship.
District level.
District level. Page 27, Annexure Z, Lordship. District level committee rejected the claim of the petitioner, Lordship, for want of the Lordship vacancy. But thing is the Lordship, at that time, Lordship, there were vacancy, Lordship. And this litigation.
How do you say that there was vacancy?
Lordship, at page number, Lordship, 45, that is, Lordship, thereafter, a special DLC meeting was held, Lordship, in the year 2014, page 45. At serial number 1, Lordship. Serial number 1, remarks column, Lordship. In this remark column, Lordship, on the last, Lordship, that it was mentioned, Lordship, there was vacancy 2006, 2007, Lordship. And petitioner's case was placed before the district level committee in the year 2007, Lordship. 4/4/2007.
Page 45, serial number?
Serial number 1, Lordship. For
Yes.
serial number 1, remarks column, Lordship.
Just read, what does it say?
Lordship, the date of application, Lordship, this is for another Lordship, another incumbent Lordship, it is Surendra Kumar, Surendranath Das.
Yes.
The date of application was 21/2000, but the application was received by DC's office from the Director of Soil Conservation in 2008. However, the proposal was not placed in the DLC due to incomplete documents. Now the required documents are submitted to the DLC. At present of age of the applicant is so years, but at the time of submission of the application of 29 years, hence the proposal may perhaps consider against the one number of vacancy of field workers for the year 2006, 2007 also. So meaning thereby, Lordship, that in the year 2006, 2007, there was vacancy, Lordship. But district level committee, when they have sit on 4/4/2007, they have considered that there was no vacancy, therefore his case was not considered, Lordship. Thereafter, Lordship, in the state level committee meeting also, Lordship, page number 47, we have annexed the decision of the state level committee's decision. There also was clearly mentioned in the year 2006, Lordship, there was vacancy.
No, what you're saying is that you were rejected in 2007.
Yes, Lordship.
And since there was no vacancy.
No vacancy,
But
there was-
as per the meetings held in 2014,
Yes,
there was another person
yes.
who also was not considered the relevant time. And his case was considered in the 2007 vacancy,
Yes, Lordship.
for which reason you could not be considered.
Lordship, it's well covered by the Debabrata Tiwari case, Lordship.
Hmm?
Debabrata Tiwari case, Lordship. It was spent there force, Lordship, Lordship, as part of OM, that OM 1615, Lordship. This clearly stated that Principle 10, Lordship, if the application of eligible candidate remain pending and cannot be considered due to want of vacancy for a period of 2 years, and from the date of making such application will require no further considerations and must be understood that to have spent their force, Lordship.
What is that?
Applicable here, Lordship.
Lordship, his father was died, Lordship, in 2000.
No,
Lordship.
what you are reading, what are you reading just now?
OM, Lordship, 2001.
It's not here in the records?
Lordship, this is OM dated 1615, Lordship.
Is it not available in the records?
No, Lordship, no. And the judgment of the Debobita Tiwari, Lordship, para 35, Lordship. Father died, Lordship, 14/1/2003, Lordship.
This principal 1 to principal 10, this was,
OM dated 1/6/15, Lordship.
you don't have a more legible copy.
Lordship, I have received this much, Lordship. OM principal 10, Lordship.
What is the basis of making this OM?
The basis of regarding compassionate appointment, Lordship.
What is the basis?
Basis of when the father of the applicant, father of died, Lordship.
Don't explain compassionate appointment. Don't explain the meaning of compassionate appointment. I think we understand that. I'm asking you, what is the basis of making this office memorandum?
Financial condition of the.
No, that is not the question, the answer I'm not looking for. On what basis this office memorandum has been prepared?
This memorandum I prepared, Lordship, on the basis of the criteria fulfill the.
There was one judgment of this court,
Lordship.
Achut Ranjan Das or something like that.
Lordship, on the basis of Achut Ranjan Das, Lordship.
Is it on that basis?
On that basis.
Oh.
And actually covered by the Debobita Tiwari case, Lordship. There are 35 stated, Lordship. I furnish that copy, Lordship.
No, what you have furnished me is a office memorandum.
In the office memorandum on the basis of that,
You're talking about some judgment.
judgment is there, Lordship. State of West Bengal versus Debobita Tiwari, Lordship. Para 35, Lordship.
Okay, but have you understood what the other side is saying?
Lordship, it is suspend their force, Lordship. and
No.
Lordship, it is completely different, Lordship.
Spend its force. It's very easy to say spend its force after 2 years. Thing is that he's saying that there was a vacancy at that time. That vacancy was utilized for some other purpose, which he is not responsible. And he has been deprived of that appointment. Because the state had failed to take into consideration the case of another person, one Surendra Nath Das. Lately, they received the application and they decided to give him that benefit of 2007 vacancy, in which the petitioner had become eligible, but he was being ousted because of filling up that post.
Lordship,
That is what they're saying.
kindly see that judgment, Lordship, it para 35 clearly stated, if the delay in part of the applicant side or a respondent side, Lordship, it has been already delayed, Lordship.
So if it's delayed, why did you appoint this person, Surendra Nath Das, then?
That, on that
Huh?
time, Lordship.
No, at that time.
In the year, Lordship, on 2003, 13 or 14, Lordship.
Can that be the answer?
Then Lordship, I will obtain the instruction, Lordship.
You want to obtain instruction?
Lordship.
Nothing will come out, Lordship, from getting the instruction. Nothing will come out from getting the instruction, Lordship, because thing is, it is very much clear, Lordship, from the records.
No, we'll give him a chance if he wants to obtain instruction. Because unless we know there's vacancy today also, we cannot say that somehow you put him in. We cannot say that. He'll have to be considered against some vacancy.
But now this Lordship, he may be accommodated in other department also, Lordship. And some of the judgment also passed by some other court also, Lordship.
Please write down. Challenge made by the petitioner is to the decision of the district level committee in its meeting held on 4/4/2007, whereby the claim for compassionate appointment made by the petitioner was rejected for want of vacancy. Stop. The learned counsel has drawn the attention of this court to the proceedings of the DLC meeting held on 10/10/2014, wherein against the vacancy for the year 2006-2007, one Sri Surendra Nath Das was considered for compassionate appointment, despite the fact that his application was of the year 2000. Stop. This was because the application was belatedly received by the Deputy Commissioner's office from the concerned department, that is Directorate of Soil Conservation, only in the year 2008. Stop. Although Mr. A. Chakrabarty, learned State Counsel, has tried to resist the argument, resist the claim by citing the case of
State of West Bengal versus that of-
just a minute. Or you dictate the order.
Sorry.
State of West Bengal and Debabrata Tiwari and others. 2023 SCC online SC 219. Bracket paragraph 35. Close bracket. And also the office memorandum dated 1/6/2015. Issued by the government of Assam in the Department of Personnel, bracket capital B. To contend that due to passage of more than 2 years after the first consideration of the after the DLC meeting held on 4/4/2007, the case of the petitioner has already spent its force. But the learned State Counsel submits that he may be given some time to obtain instructions in the matter. Stop considering these. Prayer made. The matter stands adjourned for
2 weeks.
2 weeks. This is what department?
Soil
Which-
conservation.
I am representing 1 and 2, my lord, soil conservation. At that point of time, the government of Assam representing my lord department, and from 2021, I am representing the department. And I have no record, my lord. Learned counsel may provide me the copy, my lord.
This is not a new case.
Old case, Lordship. 15, Lordship.
2015, yes, sir.
Instruction receipt.
And the
Already
Soil
the
Conservation Department
affidavit
filed
was filed
affidavit
before.
also, Lordship. Soil Conservation Department filed one affidavit also, Lordship, but in that affidavit, they have not contributed anything, Lordship.
Hmm.
Affidavit dated, Lordship,
2016.
2016, 23.
Ask him a copy. You give her a copy if she wants.
Public.
Hello, in that case, item number 20, that the date of consideration is there, my lord, written in paragraph 12 itself.
What is that?
Yes.
My lord, that item number 23 regarding that master roll worker.
Lordship had a query.
Which
effective moment, na?
Lordship had just now disposed, my lord, that date of effect will be, my lord, it will be from 1/8/2017. Lordship may kindly record it, not from the date of judgment. It is
Okay.
specifically mentioned in paragraph
With
22.
effect from 1/8/2000,
1/8/2017.
2017, okay?
17, because judgment was
Not,
passed
not
on
from the
by
date of judgment. Instead, you write with effect from 1/8/2017.
1/8.
What is this date otherwise?
Otherwise, my lord.
Why
judgment-
this date is taken?
My lord, it is from 1/8/2017 as per paragraph 22, but the judgment was pronounced on 8/6/2017.
No, my question is why, what is auspicious about 1/8/2017? What is the reason behind?
8/2017, perhaps, my lord, the division bench have on some
It must,
consideration.
it must relate to something. What is that?
It is not specifically spelled out in the judgment itself, my lord. That is also, I had also.
What date is there?
Yes, my lord, paragraph 22 is clear, my lord. Proceed may see it.
It's okay if you say,
My lord.
Mr. Kalita also, I think, agrees to that.
Because date of judgment was, my lord,
Yeah, my lord,
8/6 to.
I have given just one judgment for your lordship's consideration, so that any, regarding right to be considered, my lord, that depending upon lordship has made a query to me that Uma Devi, my lord, regarding why Uma Devi was not applicable. In this case, my lord, paragraph 7 and 8, it is mentioned, my lord, so I have, lordship will just go through it before passing.
No, we have passed the order.
My lord,
That's
post
it, right.
offenders, nothing remains, my lord. Only with regard to, my lord,
No, no.
that is my duty, my lord, point it out before this honorable
No,
court,
no.
my lord. The
I
date
have
of-
I have also submitted that, so that
Yes.
lordship can go through it before passing any.
Yes, yes.
Before passing, but we have already passed the order. Hmm.
Paragraph 7 and 8.
I'm so obliged, my lord.
Yes.
Regarding right to consideration.
Paragraph 22, I appear on behalf of the petitioner council. Three councils are there, Majumdar, Rai and Bejborua, my lords. This brief has been taken away from us, my lords, and these names may be deleted. Three names on it. One is R. Majumdar, one is P. Rai, and one is Bejborua. This brief has been taken away from us, my lords.
And then who are the others?
I don't know the other persons. my lords,
J.U. Ahmed and these
These
two.
two, my lords. Yes, these two are there. I don't know, but these three.
You're not, you're not together.
No, no, no.
They are
I
not
am
together.
on only behalf of
They are
Mr.
not
Majumdar.
together.
We're not together.
Whereas Gisur was initially appointed, maybe, here subsequently Mr. Mazumdar started appearing.
And
Now-
Mr. Majumdar's, I appear on his behalf, my lord. This brief has been taken away from us also.
Then what to do? What is the issue?
Lordship may post it after vacation. In the meantime, they are SSB Jawan's lordship. I am representing since the department, I will inform them. Somebody may be interested in this outcome of this lordship.
No, what I was intending to,
They assailed that change of promotional policy. Earlier it was a
Yes, yes.
divisional wise. Now we have changes to group center level. So chances may be diminished. That's why. So that lordship. that's the
issue is no more life or what?
That may be a live lordship. Because in the prayer, they made that they wants to challenge that promotional policy, which has been changed from the divisional level to the group center level.
See, another reason why I asked you was if they are no longer representing them, then should not a notice go to them directly
Yes,
to
I
make
was-
alternative
that is
arrangement?
suggested.
Lordship, that is proper.
That will be proper, madam.
If they don't come back, then we can just close it up.
Yes, madam.
Lordship.
Your Mr.
D. Gogoi, madam.
Mr. D. Gogoi, Learned Counsel submits that Mr. R. Mazumdar, comma, Mrs. P. Rai
Right, yes.
and
H.
Mr. H. Bej Borua are no longer engaged in the case since the petitioners have withdrawn the brief from them. And that he speaks on behalf of Mr.
Majumdar.
R. Mazumdar. Full stop. He summons that the three names may be deleted. Mr. B. Chakrabarty, Learned CGC, appears for the respondents. Respondent number one
All the respondents.
appears for the respondents. Next para, as prayed for. The names of so-and-so, 3 names, huh? Are uh, stands deleted. As counsels for the petitioners. Stop registry to do the needful. Next para. Registry shall also issue notice to the petitioners. How many of them?
Two petitioners.
By registered post with AD due. Informing them that the matter will be fixed again. The matter will be listed again on 5th of November. List the case again on 5th of November.
Publish.
I had one more line. It will be listed again on 5th of November. And that they should make alternative arrangement. Stop that much. List again on 5th of November.
May it please, your lordship.
Yes.
So this matter relates to lordship, dismissal from service lordship. The petitioner was working as a constable lordship in the Assam Police Department lordship. And a departmental inquiry has been conducted and later on he was dismissed from service lordship. That is at annex of lordship. Page 30 is a dismissal order lordship.
When was he dismissed?
On 17 January 2017 lordship. So we have challenged this order lordship on the ground that lordship there are some procedural irregularity lordship while conducting the departmental proceeding as well as lordship on the ground that the punishment was excessive relating to his conduct and the other is that lordship there is actually no evidence on the ground of no evidence lordship because my lord subsequently his conviction he was acquitted in the criminal proceeding lordship.
So
And not in the
does it mean automatic reinstatement?
no lordship, but
Then?
criminal proceeding lordship, it was held by the trial court that lordship, the FSL report, which was relied on by the departmental proceeding, that was not at all lordship as per the procedure, because my lord, the samples which have been sent for the FSL are not the same samples that had been seized from the petitioner lordship.
In criminal case?
Lordship. You ask me, can you have a look at the
So
lordship?
that was the ground for acquittal.
Lordship. Also, can you have a look at the so cause notice that is annexure 1 page 16 lordship also. Statement of allegation is at page 17 lordship. May I read lordship?
Yes.
While UBC 1601 Lalimia Chaudhary of Police Commissionerate Guwahati was attached to Dispur PS Traffic Branch on 4/2/2016, an FIR was lodged by complainant Sri Siddheswar Boru, SI of Police Dispur PS, against him, stating that on the same day, while he was on mobile patrolling duty, he detected 2 numbers of police personnel are selling drugs suspected to be brown sugar at the supermarket and Srinagar area. He apprehended both the persons, namely Mohammad Lalimia Chaudhary of Dispur PS Traffic Branch and Mohammad Salauddin Chaudhary, AB Constable of GRP Headquarters Pandu, and recovered a brown color substance suspected to be drugs from their possession, and accordingly seized by observing all the formalities of NDPS Act. At that time,
He was on traffic duty at Srinagar and ABC 247 Salahuddin Chaudhary of GRP Pandu was detailed for SAG, that is South Asian Game duty, and was on duty at supermarket under Dispur PS. During investigation of the case, he could not produce any valid documents regarding selling of drugs that is suspected to be brown sugar. Hence, he has arrested and forwarded to the Honorable Chief Judicial Magistrate Kamrup M Court on 5/2/2016 in connection with Dispur PS case number so under Section 21A 29 NDPS Act. Allegation has been brought against him that he, being a member of discipline force and was on traffic duty at Srinagar, he was apprehended at the time of selling of drugs suspected to be brown sugar at Srinagar area and recovered a brown color substance suspected to be drugs from his possession and accordingly seized by observing all the formalities of NDPS and arrested and forwarded to the judicial custody on 5/2/2016. His above act amounts to total dereliction of duty, which unbecoming of a member of discipline force. He has failed to discharge his duties lawfully. Therefore, his above act has been charged with gross misconduct and dereliction of duty as a responsible police personnel. And my lord, there is a list of witnesses, Lordship.
You see, this second paragraph, what does it mean?
Lordship.
During investigation of the case, he could not produce any valid documents regarding selling of drugs.
Lordship.
Means, what does it mean?
I could not also answer, how can I, Lordship, produce valid document selling of drugs?
No,
like-
it means that you could not produce. I mean, the
Lordship.
petitioner could not
Yes,
produce.
yes, Lordship. And a list of witnesses were examined, Lordship, Sri Minal Deka, APS, Sri Bindul Borua, SI Siddheswar Boru, SI Novosoikia, N Deka, Salahuddin Chaudhary, and he is one of the accused in the Dispur PS case, Lordship. Witness number 6, Lordship. And a list of documents were certified copy of FIR, Dispur PS case, and certified copy of GD number so-and-so, copy of WTO of IC Dispur PS, and certified copy of detailed report of Dispur PS case number so-and-so, and copy of detailed report of ADCP crime. And here, Lordship, we have found that, Lordship, FSL report on which the disciplinary authority has relied on has not been mentioned in the list of documents, Lordship.
Where's the inquiry report?
Lordship. That is on page, Lordship, 4. This is the findings of the,
Page 4.
no, annexure 4, page 23, Lordship. May I read, Lordship? Page 23, Lordship.
Read the operative findings,
Lordship.
page 25A.
Lord. Observation, Lordship. From the statement of witnesses, statement of the delinquent, co-accused ABC Salahuddin Chaudhary of GRP Pandu, facts and circumstances, and documentary records of Dispur PS, it transpires without doubt that on 4/2/2016, the delinquent UBC Lalumia Chaudhary was found to be in possession of drug-like substances suspected to be brown sugar. During duty hours at Srinagar area under Dispur police station by SI UB Siddheswar Boro and PS party, and accordingly apprehended and brought to the PS. It is also evident from the statement.
Just a minute, from where are you reading?
Page 25, Lordship, observations.
No.
Down below, madam. Down below, second last paragraph.
I had asked you to read 25A. You're reading 25. Okay, read. I was on 25A. Findings. Anyway, observations. You read observations. Yes.
There's the observation, so.
Read again.
Lordship. From the statement of witnesses, statement of the delinquent, who accused ABC Salahuddin Chaudhary of GRP Pandu, facts and circumstances, and documentary records of Dispur PS, it transpires without doubt that on 4/2/2016, the delinquent UBC Lalumia Chaudhary was found to be in possession of drug-like substances suspected to be brown sugar during duty hours at Srinagar area under Dispur Police Station by SI UB Siddheshwar Boro and PS party, and accordingly apprehended and brought to the PS. It is also evident from the statement of the delinquent himself that the delinquent and co-accused Salahuddin Chaudhary, being relatives, were closely in touch with each other, and that the co-accused Salahuddin Chaudhary is addicted to drugs. The main defense put up by the delinquent is that he has been arrested based on the allegation statement of co-accused ABC Salahuddin Chaudhary, and that the arresting authorities did not follow the proper procedure of law under NDPS Act at the time of making this arrest. Now,
Salahuddin is also police.
Lordship,
Both of you are police.
Lordship.
What happened to him? He has also been removed,
No, he has not been removed, Lordship. He was later on reinstated, Lordship.
reinstated.
Lordship.
No DP against him.
So far, my information is concerned, perhaps no DP has been conducted against him.
Yes, then
But as regards arresting of the delinquent is concerned,
AC.
there is no doubt that he was apprehended during duty hours after being found to be in possession of 3 numbers of small size plastic containers containing drug-like substances, suspected brown sugar, while conducting body search, and that he could not provide any valid documents in support of possessing the same. This fact itself is unbecoming of a member of a disciplined force, and moreover, the delinquent in his statement has himself admitted to it, and which is also corroborated by the statements of the other witnesses, FIR, and other related documents of the police station. In his statement, the delinquent has also alleged that his relative and co-accused ABC Salahuddin Chaudhary, who is a drug addict and used to frequent his house, had kept the drug-like substances in his uniform jacket pocket. This is the defense lordship. But that point cannot be accepted because being a member of the discipline force, it was his duty to remain alert and be aware of whatever he was carrying with himself while going out for duty, and particularly when he knew that he was frequently in touch with an addicted person like ABC Salahuddin Chaudhary. So these are the observations, Lordship. Then the findings, upon careful examination of statement of the delinquent, witnesses, police station records, statement of co-accused ABC Salahuddin Chaudhary, facts and circumstances, an expert opinion report from FSL, Hanapara, confirming the seized drug-like substances to be heroin, which has been collected by the eye of Dispur PS case number so and so. It can be conclusively deduced that the allegation of misconduct and total dereliction on the part of delinquent UBC Lalimia Chaudhary by being in possession of drugs during active duty hours stands proved, submitted to the disciplinary authority for favor of fine pay result. This is the report of the inquiry officer. And to that report, Lordship, I have submitted my representation. That is an annexure 5, Lordship, page 26. I have I have raised, Lordship, some objection in the DP, Lordship, regarding that I was not allowed to cross-examine the witnesses, Lordship. And all the Lordship statement of the witnesses have been taken behind my back, Lordship. These are the Lordship objection I have raised before the disciplinary authority. My Lord, we have found that, Lordship, in the inquiry report, it was the observation that, my Lord, it was my part to check the uniform before wearing it, Lordship. This is the only thing that they have taken as an observation, Lordship, for convicting me, Lordship, in the DP. Just my lord, the inquiry officer has observed that as I have taken the defense that my lord, Mr. Salahuddin Chaudhary, one of my relative who is a drug addict, may put the drug-like substances in my pocket of the uniform, Lordship. To that defense, Lordship, it is the observation of the inquiry officer that it is my duty to check my uniform before wearing it, Lordship. And this is the misconduct on my part, Lordship, and total dereliction of duty, Lordship. 25A, Lordship, in second paragraph. May I read again, Lordship? Okay. Lordship?
Was it your case that somebody had put the drugs in your pocket?
Lordship, that is the Salahuddin Chaudhary with one of my relative, Lordship.
No, is that your case
Lordship.
in the department proceeding?
Lordship, I have raised objection, Lordship, regarding the procedural part, Lordship, in the departmental proceeding, Lordship, that I was not allowed to cross-examine the witnesses.
That is a different thing. I'm asking you,
Lordship,
pointedly, I'm asking you, is it your case before the departmental proceeding that Chaudhary had kept the drugs in your pocket?
Lordship,
Where have you stated that?
oh, Lordship,
You have submitted your written statement.
Lordship, I have submitted, Lordship. Annexure-
Have you mentioned that?
Lordship, Annexure 2, Lordship. Page 18.
Where have you stated it? Nowhere stated anywhere. That somebody planted that drugs in your pocket.
Lordship.
Was your statement recorded?
Lordship, perhaps.
Where's your
let us-
statement? Hmm?
Maybe to say this, before the WS1.
Yes, page 25.
Lordship,
Second para, page 25.
sorry that. Statement of delinquent, Lordship.
In the show cause reply, you did not say that. But during the inquiry, you made, your statement was recorded. You say that this Chaudhary had planted this thing in your pocket,
Okay.
which according to the inquiry officer was not believable, saying that you should have checked your uniform before wearing it, while wearing it. How much is the drugs recovered?
And as per the seizure list, it was 0.090 gram, Lordship.
0.09 grams.
0.09 milligram, Lordship.
What, how much is that? It's not even 1 gram.
Lordship. The seizure, less than one. Seizure list,
Where's the Caesar list? Where is the FSL?
seizure list, Lordship, we have submitted it, it is in the record, Lordship, perhaps.
You have the records with you?
My lord, one thing is, my lord, we can always deliberate, my lord, records, my lord. But thing is that, my lord, annexure 1, page 16, my lord has asked a very vital question at the very first instance, my lord. May I read that page 16, annexure 1, my lord, that show cause notice, my lord.
What is that?
My lord has asked that, I'm reading for para 3, my lord. During investigation of the case, you could not produce any valid document regarding selling of drugs suspect to be brown sugar. So my lord has put a question, this, what is regarding that valid document, my lord? My lord, he was in possession of some drugs, my lord, and valid document, why it is asked, my lord, whether that is something legal, my lord, drugs, any medical prescription drugs or something like that. He could not produce anything, my lord, on him when he was carrying that. So that is why, my lord, this query, in SOCO's notice, my lord, it is written, my lord, that during investigation of the case, you could not produce any valid document regarding selling of drugs. He was selling some drugs, my lord, illegal drugs, and that is not supported by any legal prescription that is there. Coming back to that, my lord, after this, now, my lord, the finding. In observation, my lord, in page 25, the second paragraph, my lord, I'm reading. It is also evident from the statement of the delinquent of himself that the delinquent and the co-accused Salahuddin being relative were closely in touch with each other, and that the co-accused Salahuddin Chaudhary is addicted to drugs. The main defense put by the delinquent is that he has been arrested based on the allegation statement of the co-accused Salahuddin Chaudhary, and that the arresting authorities did not follow the proper procedure under NDPS Act at the time of making his arrest. But as regards arresting the delinquent is concerned, there is no doubt that he was apprehended during duty hours. My lord, duty hours, when a person is he's from a discipline force, my lord, and when in a duty hour in a uniform, my lord, he should conduct himself as a disciplined, my lord, person from the force. That he, my lord, miserably failed.
Anyway, Mr. Dhar,
My lord.
I think you should produce the records.
My lord.
This is of which year, DP?
2017.
2017, 16?
17,
17, and you had dismissed on
2017.
2017. You preferred appeal?
Appeal, yeah, my lord.
Appeal also rejected.
Rejected, my lord.
Rejected, lord.
Appeal is, the order is in page number 39.
Also, in the appeal, lordship, we have raised the objection that we have not been allowed to cross-examine the witnesses, but that point has not been considered.
My lord will come, what are the substances was recovered, my lord, in that appeal order is there. Not that what my friend was, my lord, submitting in para second, my lord, down below. What are the components, my lord, recovered? 1.3 numbers of small size plastic container having suspected drugs like substance. Second is 4 numbers of empty plastic container, 4 numbers of nitrosam 10 tablets, 1 syringe suspect to be used for pushing the drugs. These are the materials, my lord, recovered from his possession during, my lord, the checking, my lord.
You
on him.
produce the DP?
Lordship,
I think we'll do that first.
also regarding the record, lordship, they have submitted earlier that they have lost the record, lordship.
Huh?
They
My
have
lord,
lost the record, lordship.
My lord,
This is the case, lordship. Here,
You have lost the records.
my lord, it is, we have stated in this affidavit only that record, my lord, is missing, my lord. And SIT was formed, my lord, and we could not trace it. It is, we have stated, I'm being very fair.
SIT was formed? You mean to say that earlier the records was called also?
Yes, my lord. My lord, I have the affidavit filed by respondent number 4, 5, and 6.
By which order it was called, records? Hmm. 18/8/2017. That was the order.
My lord.
Then,
My lord has to.
May I submit one thing, Lordship? So Lordship, may kindly have a look at the trial court judgment, Lordship, regarding the entire seized documents, Lordship. Actually, there is no such seized documents perhaps, Lordship. It's a pre-planned manner, Lordship. The petitioner has been arrested, Lordship.
but thing is that why should your fellow policeman arrest you for nothing? Something was recovered from you.
Kindly have a look at page 72, Lordship, of the affidavit in reply filed by. This is the judgment of the trial court.
Where is that?
Page 72, last 4 lines, Lordship, I just point out, Lordship.
Page 70.
72. Continuing page, Lordship, affidavit in reply of the record. Here, Lordship, it was the observation of the trial court judge, Lordship. Your Lordship is page 72, Lordship. What it for your Lordship?
Paragraph?
Page 72, Lordship. Continuing paragraph, Lordship, page 34 paragraph.
Yes, read.
Further, the samples of the heroin examined by the PWT Gajendranath Deka cannot be the samples of the heroin allegedly recovered and seized from the possession of the accused persons. In view of the above, it cannot be held beyond all reasonable doubt that the alleged nitrozepam and heroin were recovered and seized from the possession of the accused Lalimia Chaudhary and Salahuddin Chaudhary. Therefore, the accused are entitled to get benefit of the same. Accordingly, they were acquitted, Lordship. And your Lordship, kindly have a look at page.
So what was the reason for the learned special judge to come to that conclusion?
Page 68, Lordship. Kindly have a look, Lordship. Page 68, paragraph 28, Lordship. Trial court judgment.
Yes.
May I read, Lordship?
Yes.
PWT Gajendranath Deka has deposed that on 6/2/2016, he was working as the joint director in the Directorate of Forensic Science, Assam. On that day, he received a parcel through the director in connection with the dispute PS case number so-and-so for examination. The parcel consisted of 8 exhibits enclosed in a seal envelope. The facsimile of the seal was found to be an emblem of Osuka pillar. Description of articles. One seal envelope marked as S1 having 2 closed polythene packets containing 4 numbers of small seal plastic container containing 130 mg, 143 milligram, 157 milligram, and 189 milligram light brown color powder substance, respectively. He marked the same as DN25 A1 to DN25/2016 A4. And secondly, one cut strip with 4 numbers of tablets branded as nitrosam 10. He has marked the same as so-and-so. And the result of examination, he had examined all the samples mentioned above as per the United Nations Drug Testing Laboratory Manual and getting tests for heroin and nitrozepam. He formed a report as follows. Exhibit DN gave positive test for heroin and percentage of heroin is so-and-so, so-and-so. The exhibit gave positive test for nitrozepam and amount of nitrozepam is exhibit so-and-so. Exhibit 1 is the report prepared by him and exhibit 1 is his signature therein. In the cross-examination, he has stated that the description of articles under para 1, the weight mentioned is only of the material, excluding the weight of the container. but PW6 Siddheswar Boru has deposed that he seized 90 milligram of heroin from the accused Salahuddin Chaudhary and 60 milligram from the accused Lalimia Chaudhary, in total 1.50 gram. But the PW2 Gajendranath Deka has deposed that samples received by them for examination consisted of 130 milligram, 143 milligram, 57 milligram, and 189 milligram. Therefore, the samples of heroin examined by the PW2 Gajendranath Deka cannot be the samples of the heroin recovered from the possession of the accused persons.
So the amount recovered from the petitioner was 1.50 grams.
No, both the accused, lordship. From the petitioner, it was 90 milligram, lordship, as per the with statement of PW6, lordship. And but as per the Caesar list, it was 0.09 milligram.
So what was recovered and what was examined did not match.
Did not match.
That was the reason you were acquitted.
Lordship.
Benefit of doubt.
Lordship. Actually, not benefit of, because, my lord, perhaps nothing has been recovered from me, lordship. Because if something has recovered, that sample has to be sent for FSL, lordship. It's a totally different samples or articles. Because it's a sample, lordship. There are some other material are also there, lordship. It's a sample amount, lordship.
So in the departmental proceeding, what has been indicated?
It was
The
this,
quantity, how much has been recovered?
This FSL report has been relied on, lordship, by the appellate authority as well as disciplinary authority, lordship.
No, in the charge.
Lordship. Charge, lordship, they have not mentioned.
It has not been quantified. How
No.
much has been recovered from you?
No, lordship. Quantity they have not mentioned, lordship. My lord, another fact is that, my lord, no FSL expert has been examined, lordship, in the DP.
FSL report is there,
Yes, sir.
available?
In original, lordship, we have submitted, perhaps it in the record, lordship.
Who has produced it?
Lordship, as per earlier order digit 12/5/2020. As per the order of this honorable court, we have produced in original, lordship.
You have produced it.
Lordship. Additionally, lordship, government was also directed to produce, lordship. As per the order of the 12/5/2022, lordship.
I have a certified copy, my lord, of the report, my lord.
It is here, it's here. Quantity is 130 mg, 143 mg, 157 mg, 189 mg, light brown. Then nitrosune 10, 4 numbers of tablets, 1 cut strip with 4 numbers. Now, this is regarding what was examined by the FSL. Correct? Now, question is, what was recovered from you? Where is it given?
This Caesar list was also there, Lordship.
Hmm?
Caesar list is also there, Lordship, in the record we have produced in the.
Caesar
original,
list.
Lordship.
Separately?
Separately. Lordship.
You have a copy of the Caesar list? What does it say? Just read it.
Yes, sir. Caesar list, MR number 21/16. Dispute PS GD number 227, dated 4/2/16. I, the undersigned, do hereby seized the below noted articles suspected to be drugs from the possession of Lalimia Chaudhary in connection with above GD number, in connection, in presence of the below noted witnesses, which were in a small plastic containers. Description of seizure articles. 1. 3 numbers of small plastic container containing suspected to be NDPS. Weight with plastic container 3.660 milligram. Weight without NDPS 3.50 milligram. Total weight of suspected NDPS 0.090 milligram. And later on, sign of witnesses.
Just a minute, just a minute. Weight of plastic container is taken, then
3
weight of the NDPS is also taken.
Lordship.
Means what?
Weight with plastic container. The whole plastic container, that is weight 3.660. And with NDPS. When it was weight without the substance, Lordship, it was 3.570. And accordingly, the weight was calculated as 0.090 milligram. After deducting the.
This is from you.
Lordship.
Then something was also recovered from
Salahuddin was it?
Petitioner is what?
Lalimia, Lordship.
Lalimia.
And from Lordship, Salahuddin, the another accused, 3 numbers of small plastic containers, 4 numbers of empty small plastic container, 4 number of tablets named nitrosum 10, and 1 syringe suspected to be used in pushing NDPS, and weight of 3 plastic NDPS 3.630, weight without plastic 3.570, total weight of suspected NDPS 0.060 gram.
This is in gram, not milligram, isn't it?
Milligram.
No.
MG.
No, I don't think so. Salahuddin Chaudhary,
Both, Lordship. MG.
it's gram. There's no mg.
Salahuddin is in MG, my lord.
MG.
Hmm?
MG, Lordship.
It's written out here, it's written 0.060 grams. How do you say it's mg?
Salahuddin. Oh, it was written gram.
Mia Chaudhary is milligram.
Milligram.
0.090 milligram.
Here, Lordship.
But for Salauddin Chaudhary, it is 0.60 grams.
Gram, sorry, Lordship. I'm not.
So the articles described in the FSL report says 130 mg. milligram.
Lordship, total 619 mg, Lordship.
Total?
Because 4 samples have been sent, Lordship.
How much is total?
There is page 68 in the small, sir, 4 numbers of small seal plastic container containing 130 milligram, 143 milligram, 157 milligram, and 189 milligram. And total will be, Lordship, 619 milligram. That is 0.619 gram.
So it's not tallying with the amount recovered. There seems to be some discrepancy also in the calculation.
But in that trial court, in the trial proceeding, they have deposed like that, Lordship.
No, trial court has said that total is 1.50 grams.
No, total, Lordship, from both the accused, Lordship. There is a 60 milligram plus 90 milligram. It's 150 milligram all total.
Okay, 1.50 grams.
That is also not tallied.
But then that also again, it's not tallying with the, like I said, the Caesar list. There are two Caesar lists.
Lordship.
One is from this Salauddin Chaudhary. Other one is from the petitioner.
Lordship.
From petitioner, it's 0.09 mg milligrams. But from Salauddin Chaudhary, it's 0.60 grams.
060 gram. 060.
But in the trial court's order, it has been shown as
60 mg.
60 mg.
Everything is, I just want to point out one thing, Lordship. Both the Caesar lists are different, Lordship, and they were, Lordship, arrested from different places, but the Caesar witnesses are same. There is something is, Lordship.
See, otherwise, see, DP is regarding what is not to punish you under the NDNPS Act. It is basically you have violated the
Misconduct. And that
misconduct, unbecoming of government servant, and all that.
That's on the basis of that I have not checked my, Lordship, uniform before wearing it. Because this is my defense that Salauddin Chaudhary may put the substances in my pocket, Lordship.
No, what is there to support your contention that he may have put it? He also may invent any story. Yes, supposing you're caught red-handed, you may say that it's because of that somebody has done this.
Lordship.
How will you prove that?
But look, in this case, particular case, Lordship, if the entire, Lordship, substances have been sent for FSL, there is a huge quantity of amount, Lordship. The amount of samples sent for the FSL. Actually, there is no amount has been seized from me, Lordship. That inference can be drawn up, Lordship. Because it's a huge amount, Lordship, the samples.
I don't know.
From where they have collected lordship? Nowhere lordship, it has come from nowhere lordship. It's
Anyway, my question was regarding the records, there was some the same could not be produced. You said some SIT has been formed. Where is that?
We have said in our affidavit, my lord,
Which affidavit?
affidavit filed by respondent number 4, 5, and 6.
In 2021,
Yes, my lord.
where have you stated?
My lord, it's in, I don't have a continuation para. My lord, para 5. It starts from para 5. It continues.
This S. Chaudhary has been reinstated.
My information is that he has been instated.
They have stated in their affidavit in reply,
No, my lord.
paragraph 5.
Yes, yes. And my lord, may I come in specific lordship? I have heard the lordship judgment of the honorable Supreme Court regarding equity lordship. A person has been lordship.
Wait. I'm asking him about the records. He said that SIT was formed to search for the records.
My lord. My lord, this para 5, it continues first page, second page, the third page, my lord. Para 5.
Para 5 of what?
Para 5 of the affidavit, my lord, filed by respondent number 4, 5, and 6. It's a very big paragraph, my lord. It
Okay. Wait.
para second page,
I was
then the next page, my lord.
The paragraph 5 I was looking at was the reply.
No, my lord.
So paragraph 5. What is the page? Inner page number?
My lord,
Show me the relevant portion.
my lord,
No, do we have to read the affidavit
no,
just to find out that
No.
the records have been lost?
no, my lord.
You just point out, where is it?
My lord, I don't have the running page, the number has changed, my lord, page number. That's why I was, my lord, into the paragraph. Para 5,
I'm not asking you the running page. I'm asking you the inner page. You
Inner
must be
page.
having inner page. It is
Uh,
your affidavit.
para, my lord, page 45. Page 45, my lord.
Yes, where? Which part?
Page 45, the third paragraph, my lord.
Read.
The deponent further respectfully states that thereafter the petitioner approached the High Court, Honorable High Court, by filing the instant writ petition, and in connection with the writ petition's para-wise comments was as well as departmental proceeding records were sought by the Government Council. But neither the para-wise comment nor the departmental proceeding records could be submitted on the fixed date because of the missing departmental proceeding file number such and such, along with service records.
Along with service record means
All his service records.
his records also lost.
It was together, my lord. When DP is contacted, my lord, basically they pull the service record also, my lord, because everything all over the record, my lord. In this regard, reports are submitted seeking extension of time to trace out the missing departmental proceeding file with service records for filing reply to the Honorable Court. Thereafter, a team was constituted for thorough search of the records at reserve office by an office order dated such and such. This such and such Assistant Commissioner of Police Reserve Guwahati. This is the team, my lord, made in Inspector such and such Police Commissionerate. And number 3, SI such and such. Accordingly, 6 numbers of sub teams were constituted to physically check the office records and to trace out the missing departmental proceeding file with service records. The team has submitted reports stating that they have searched vigorously by scrutinizing all reserved records, engaging additional manpower, but failed to trace the missing departmental proceeding file with service records. Thereafter, an FIR was lodged at Panbajar Police Station on 6/5/19 in connection with the untraced departmental proceeding file and service records of the petitioner. And a criminal case has been registered.
So what
based on
happened to the
FIR.
case?
So, my lord, thereafter, my lord, there
Thereafter,
is
nothing.
nothing, my lord.
This is affidavit filed in 2021.
Kindly produce the order dated 11/2024, lordship. From the Government Council, it was submitted that final report has been submitted. 2024. Paragraph lordship, last 3 lines.
Okay, so what are the grounds you've taken?
First round in the lordship, I have not been given the opportunity to cross-examine the witnesses, lordship. That cross-examination part, lordship, is prescribed in the statute itself, lordship. That is
Who are the witnesses? Who are the witnesses which according to you were not cross-examined by you? Now the records are not here. Whatever records are available here is the show cause notice, the dismissal order is there,
Yes, madam.
and what else is there?
Inquiry report is there. Madam.
Inquiry report, that much only.
Appellate order, lordship.
What does the inquiry report say? Regarding your not being given a chance to cross-examine?
I have raised this point before the lordship disciplinary authority, lordship. The order, in the execution order, it has not been discussed. I have been given the my lordship representation for the disciplinary authority is at page 26, lordship. Paragraph 9, page 27.
Mr. Dhar, is it correct that no chance was given?
Not without record. But my lord,
Inquiry report is here.
inquiry report is here, my lord.
Normally it is mentioned
Mentioned.
in whenever DP is drawn that the delinquent was given chance to cross-examine, all that, all these things are written. Where is it written here? It's not written anywhere. Instead, he was cross-examined.
Yes.
Petitioner's statement was taken and he was cross-examined. But regarding the prosecution witnesses or departmental witnesses, how many of them? 6 of them.
6.
There's nothing mentioned where in the inquiry report that petitioner was given chance to cross-examine them. Then on what basis this Chaudhary, he was also inquired? The other co-accused person?
Fine function structure for DP has been conducted. My lord, in the
This is not a
restriction itself, lordship, I have mentioned that they have not denied my statement, lordship.
No, you say no DP is drawn.
Page 20, paragraph 24, lordship.
Then why, and what made you make this statement then in paragraph 5 of reply affidavit? Sri Salahuddin Chaudhary has already been reinstated by the respondent authority.
reinstatement means he was, my lord, removed.
Reinstated,
Suspended actually, lordship.
suspended.
If suspension, even my lord DP was drawn.
Not necessarily. Sometimes they don't draw, so they suspend and just take him back.
The repetition itself, also I mentioned it, but paragraph 24, page 10, in my repetition also. Paragraph 24 also. That is the incidents of Salahuddin Chaudhary, who has been arrested and suspended from service along with the petitioner, but he has been released from and reinstated in service. But paragraph 20,
Just check up.
paragraph 6 of their affidavit in opposition.
Anything there?
May I read, Lordship?
I've read it already.
Lordship.
So you are saying petitioner was not given a chance to cross-examine.
There is services, discipline and appeal rules, like the provision, Lordship, for allowing me to cross-examine the witnesses.
What is that provision? Can you quote it?
The Assam Services, Discipline and Appeal Rules, Lordship, sub-rule 6 of Rule 9, Lordship. 9 says, Lordship, procedure for imposing penalties.
Can you give me that book? Please read.
Sub-rule 6, Lordship. The inquiring authority shall, in the course of the inquiry, consider such documentary evidence, take such oral evidence as may be relevant or material in regard to the charges. The government servants shall be entitled to cross-examine witnesses, examine in support of the charges and person, and produce documentary oral evidence in his defense. The person presenting the case in support of the charges shall be entitled to cross-examine the government servant and the witnesses examined in his defense.
Yes, what is the next point?
Kindly we look at Rule 8, Lordship. Rules 964, Lordship. The authority.
Yes, Rule 8.
Sub-rule 3, Lordship.
Yes.
Notwithstanding anything contained in this rule, no penalty is specified in clauses 4 to 7 of Rule 7 shall be imposed by an authority lower than the appointing authority.
So who imposed the penalty?
That is Deputy Commissioner of Police.
And who appointed you?
PIC admin.
You're a constable.
Only constable.
Constable is not appointed by DIG. Where is your appointment order?
Actually, my lord, deputy commissioner is in the commissionerate, my lord. You always they have a delegate power from the commissioner, my lord. He's a constable, so he's under the commissionerate, my lord.
Hmm.
So, my lord, there is always a delegated power, my lord. Commissioner delegates to the deputy commissioner, my lord. And he is a constable.
When it was specific, not only the appointing authority lordship. Just to me, peruse the lordship,
Exactly.
Where's your pleading? Pleadings to that effect. I don't think it's there.
I have written lordship. But can we-
Only synopsis will not do.
Nine lordship.
Huh?
Can of 29, sir. Submitted that the present is the punishment of discipline is imposed on the
This is regarding proportionality.
lordship. You know,
So your main thing is cross-examination denied. What else?
Now this, in the appellate authority has also not considered this plea of cross-examination of witnesses. May not- Appellate authority. I have raised that point before the appellate authority.
Where is that? Page?
Sir, 8 lordship. 32. The appellate authority.
Yes, where is the relevant portion?
There are 14 lordship.
Paragraph 14.
That's how my dissatisfaction with the findings of the input not been afforded an opportunity to cross-examine the witnesses. The opportunity will provide both might have been different. Your lordship may kindly will look at 23 lordship.
Before that, let us see, let us not travel here and there. Paragraph 14, against that, now appeal disposal order is at page 39. Hmm.
Page 40 lordship, the counts have been considered. Last paragraph.
Only 5 grounds.
5 grounds. This part has not been taken in.
Hmm. Yes, what next?
Rule 23 says about Lordship consideration of appeal, Lordship. Rule 23, Lordship.
Just a minute. Yes, read.
Sub-rule 2, Lordship.
Hmm.
The case of an appeal against an order imposing any of the penalties specified in Rule 7, the appellate authority shall consider A, whether the procedure prescribed in these rules has been complied with, and if not, whether such non-compliance has resulted in violation of any provisions, the Constitution, or in failure of justice. Whether the findings are justified, and C, whether the penalty imposed is excessive, adequate, or inadequate.
So I think you're relying upon A.
Lordship. And even also we have relied on the C also, whether the penalty imposed is excessive, adequate, or inadequate. Because that pleading we have taken in the.
So how do you say it's excessive?
But my lord, my defense is that, again, I have to say this, that Lordship, I only ground the observation taken by the inquiry officer here, I have not checked the uniform which I have put while I am going to the duty. And my defense was that, Lordship, some other person may have put it in my pocket, Lordship. In that case, the observation is that being a discipline member of the discipline force, Lordship, I have to check. This is the misconduct, Lordship.
No. You have to check. You have not checked. There's another thing, but in fact, the fact remains that something was recovered from you.
That is one of the trial court totally done. I perhaps my understanding is.
You know, it is not that it was not recovered from you. Trial court has acquitted you technically on the technical ground that this much is recovered, this much quantity has been examined. How can it be?
Says about that only this much of amount has been recovered from me, Lordship. So that is their document. It has been says observing the.
Caesar list talks about grams. No, milligrams. Where is that Caesar list?
Kindly have checked the point A, Lordship.
Caesar list talks about grams in respect of this Chaudhary. Salahuddin Chaudhary, grams. In respect of you, it is milligrams. So grams and milligrams, if they are combined together, it will be quite a substantial amount. But trial court has taken it as milligrams in both cases. So anyway, we don't have anything to say anything about that. But trial has proceeded on a different premise, whether you're guilty of possessing that amount or not. But in disciplinary proceedings.
The witnesses are same, Lordship. That is the only can take the defense that the person has been arrested in 10 places. But the Caesar witnesses are same, Lordship. Place, Lordship.
There are so many judgments for and against. You may say that in your case, if the charges in the departmental proceedings and the charges in the criminal case are one and the same, based on the same set of facts which are identical, then you may have the benefit of acquittal be considered in your departmental proceedings as well, so that you can be exonerated. But then again, there are decisions which says that the test is different. Criminal cases prove beyond reasonable doubt. Departmental is preponderance of probability, and at the same time, what has to be seen is whether you have violated the norms and rules of the department, unbecoming of a government servant, all that. So all these things are there, you see, both sides. But what is glaring at this stage is perhaps the cross-examination part. It is silent in the inquiry report, isn't it? It is silent.
Point before the disciplinary authority also, Lordship.
Where? How?
I representation, Lordship. With the inquiry.
Show me. Page number, paragraph number,
There are 9, Lordship.
page.
Page 27. Lordship. Page 27, paragraph 9. Lordship. I discussion with the finding not been afforded an opportunity to cross examine.
Mhm.
But in the witnesses part, Lordship, before the DP, Lordship, but all the witnesses are hearsay, Lordship, evidences.
What about that personnel who had arrested you? He was of which rank? Somebody from the sub-inspector. What is his name? Huh?
Yes, sir, Bolu.
Was he examined?
Yes. Yes, 5, page 24, my lord, chair number 5.
He's a sub-inspector. UB. Now, who are authorized to seize drugs in the Assam police?
He is attached to Dispur police station, means he's he's sub-inspector, he's authorized, my lord.
He's authorized.
He is authorized.
But he does not know how to seize the drugs. There is a procedure. Because NDNPS Act is one act which is very stringent. That is why to establish the guilt of a person also, strict test is required. The kind of statement is made is too casual. We found him somewhere and we arrested him and all that. He should mention this was seized, these people were called. We informed him about his right, all that thing. Nothing is there. This is too brief a statement.
Principal rightly pointed out this trial court judgment, Lordship, it was observed by the learned trial judge that, Lordship, there is procedural irregularity in searching my pockets, etc. Kindly have a look at page 30, paragraph 31, page 69, Lordship.
It's okay, it's okay.
But admittedly, the so-and-so were recovered from the bodies of the accused Alimia and Salahuddin, but as can be seen from the testimonies of the prosecutors discussed above, admittedly, the bodies of the accused were not searched in presence of any gazetted officer or magistrate. Is the some gazetted officer or
Who is the disciplinary authority in your case? Respondent number?
6, Lordship.
6. So that is your case. Mr. Dhar, anything to submit? We'll close the matter.
Yes, my lord. My lord, basically here we have to distinguish two things, my lord. The trial and the DP, my lord. Trial is for my lord for his conviction in the NDPS case. Whereas my lord, in DP, it's all about, my lord, whether he has violated the service rules. Being a my lord, person from a disciplined police force, it's my lord, his solemn, my lord, priority that he should know what he is wearing and what he is carrying on his body. That is the first thing, my lord. Being in a police, if I don't know, my lord, how will I, my lord, conduct myself in the public, my lord, and secure, my lord, whatever, my lord, a task is given to me, my lord. There is a very first instance, my lord. He just cannot shy away telling that I did not know somebody has put drugs in my body, in my uniform. That is the first thing, my lord. He has to secure himself first. Unless he knows how to secure himself, being a policeman, how will secure the public? So, my lord, that is why, my lord, the inquiry officer, my lord, has rightly negated that this story cannot, my lord, sustain. So, that is the first thing, my lord. The allegation that he did not know, that was on him. This is my first argument. Second is, my lord, regarding that judgment, my lord, the trial court's order, my lord. In the last page, my lord, I will just read the order, my lord, the final order. Para 35. In the result from the facts and circumstances of the case and above discussion, I hold that the prosecution has failed to bring home the charges under section 21A and 29 of the NDPS Act against the accused Lalmia Chaudhary and Salahuddin Chaudhary beyond all reasonable doubt. Hence, I acquit them the benefit. I acquit giving them the benefit of doubt. They are, my lord. So basically, my lord, they are acquitted only on the ground of benefit of doubt, my lord. It is not that beyond reasonable doubt, my lord. My lord, they have been given, they have been acquitted, my lord. There is a confusion regarding the quantity, procedure of seizure, my lord, held in the trial procedure, my lord. That is all, my lord. But, my lord, there was always a, my lord, he stated maybe somebody has put it. He did not deny, my lord, that it was not recovered from upon him, my lord. He stated during the inquiry, my lord, that maybe somebody has put it in his uniform, meaning thereby, my lord, that he did not flatly deny that, yes, you did not recover. That was his not his statement, my lord. So, my lord, there was a recovery. Yes, my lord.
That part, that would not be an excuse in the criminal trial, isn't it?
Yes, my lord.
Who has given it, who has taken, but the fact of recovery is from you.
Yes.
Then that will be sufficient.
That will be sufficient, my lord.
Isn't it?
Yes, my lord. And my lord, here is a case, my lord, it's not about the criminal trial, my lord. This is a DP. We are only on the thing that, my lord, being a policeman, whether can we keep him in a police force who conducts himself in such a way? That is a bigger question, my lord. Will it be healthy for us to continue with such person, my lord, to keep in a police force who could not, my lord, secure his uniform? That is his statement. That one of my friend or relative may have put it in my pocket. My lord, that is a very basic thing, my lord. He has to know how to secure himself first. Then only he can secure the public property, my lord. He is a policeman. That has to be, my lord. First thing has to be, my lord. We have to keep, my lord, in mind, my lord. So, my lord, my submission is that, my lord, we conducted the inquiry in a very rightful way. And my lord, removal from service, my lord, is just. Such, my lord, person cannot be kept in a disciplined force, my lord. It will be very harmful, my lord, for public interest.
Then what do you say about the denial of cross-examination?
Denial of cross-examination, my lord. He was heard, my lord, in appellate thing.
No, he has been time and again saying in his representation against the inquiry, in his appeal, even in this writ petition, there seems to be no answer for that, especially after the court is informed that the records are lost. So we have to go by what is available before us only.
Yes, my lord. What is before your lordship, my lord? If you go by the
Okay,
document.
let me close the matter.
My lord.
Hmm?
Regarding the technical, I am just like to submit to judgment lordship. Identical witnesses in both.
Ah.
Ramlal versus.
You give whatever. I'm dictating just now.
Lordship.
Now, just you must assist me about the facts. Okay. Your good name? What is your name?
R. Phukan, lordship.
Heard Mr. R. Phukan, learned counsel for the petitioner, and Mr. R. Dhar, learned state counsel appearing for the respondents. Stop. By filing this writ petition, the petitioner has challenged the departmental proceedings drawn against him. That is departmental proceeding bearing number 8 of 2016. From the inquiry report, the impugn order dated 18/1/2017, bracket annexure 7, by which he was removed from service, dismissed from service, and the order dated 25/7/2017, passed by the appellate authority, by which his appeal was rejected by the appellate authority. Next para. Brief facts of the case is that the petitioner, along with one Salahuddin Chowdhury, were arrested. What is the date? Sorry?
February 2016.
on 4/2/2016. On the ground of alleged recovery of certain contraband substance from their possession. Stop. Following the same, Department Proceeding number 8 of 2016 was drawn against the petitioner. And at the same time, a criminal proceeding was also initiated against him. Stop. The petitioner was served with the show cause notice dated 27/2/2016, bracket annexure 1. Along with statement of allegations asking him to show cause as to why appropriate penalty as prescribed by the Assam Services, bracket, discipline and appeal, close bracket, rules, comma, 1964, open bracket, rules of 1964, close bracket, should not be inflicted upon him for his misconduct. Stop. Along with the show cause notice, comma, a list of witnesses to be examined by the department and the list of documents to be relied upon were also enclosed. Stop. In response to the show cause notice, comma, the petitioner submitted his reply on 19/3/2016, correct? Denying the allegation made against him. While stating that he never indulged himself in selling of any contraband substances. And that the drawal of criminal proceedings against him was also not called for. He thus submit that he therefore submitted that the departmental proceedings drawn against him may be dropped. Stop. However, the departmental proceedings against the petitioner proceeded, in which the departmental witnesses were examined and also the petitioner himself. Stop. Consequently, the inquiry officer submitted his inquiry report from where did you get the date? Hmm? Where?
Annexure 7.
Just give me the date.
10,016.
On 18/10/2016. With the finding that the charges made against the petitioner were approved. Stop. The petitioner was thereafter furnished with a copy of the inquiry report on 29/12/2016, asking him to submit his representation. Within a period of 10 days from the date of receipt of the communication. To stop, the petitioner then submitted his representation on 7/1/2017. And the discipline authority not being satisfied with the petitioner's reply, public representation, dismissed him from service with immediate effect by the impugn order dated 17/1/2017. Which was signed on. No. Seventeen 1/2017, okay, which was signed on 18/1/2017. Next para, the petitioner then preferred an appeal before the appellate authority. No date, did also.
70.
For me, you're saying that.
30.
On 9/2/2017. But the appellate authority, by the impugn order dated 25/7/2017, rejected his appeal. Stop, I grieve the petitioners before this court. Next para. You're Mr. R. Phukan, isn't it? Next para, Mr. R. Phukan, learned counsel for the petitioner, submits that by dismissing, isn't it? where's this? But by dismissing the petitioner from service, grave injustice has been caused to him. In view of the fact that during the departmental proceeding, the petitioner was not given any opportunity to cross-examine the, how many witnesses? 5 or 6? 6 departmental witnesses. Stop. He submits that against the inquiry report made against him, the petitioner also submitted his representation stating that an opportunity to cross-examine the departmental witnesses was not given to him. But the discipline authority did not pay heed to his representation and proceeded to dismiss him from service. So likewise, even the appellate authority failed to consider this aspect of the matter, despite the petitioner having taken such ground. Stop. The learned counsel further submits that it is the case of the petitioner that the alleged contraband substance said to have been seized from the petitioner does not belong to him, and in fact, it was placed in his pocket. Should we name him by some other, by Salahuddin Chaudhary? So for this reason, the penalty of dismissal from service imposed upon the petitioner is highly excessive and not highly excessive and liable and should be interfered with by this court. To stop, he also submits that Salahuddin Chaudhary, although was initially suspended, but later he was reinstated back into service. And therefore, the petitioner has only been made a scapegoat. Next paragraph. The learned counsel further submits that insofar as the criminal trial is concerned, the learned trial court was of the view that the prosecution failed to prove their case against the petitioner beyond reasonable doubt, particularly in view of the fact that the amount which was said to be recovered from the petitioner and the amount which was sent before the FSL did not match. Stop. Since both the departmental proceedings as well as the criminal trial proceedings were initiated on the same set of facts and allegations, the petitioner having been acquitted by the trial court, the order of his dismissal from service should also be set aside. In support of his submission, the learned counsel has relied upon the case of Ramlal versus State of Rajasthan and others. 2024, 1 SEC 175. Anything you want to add?
Thing is that for the appointing authority, then disciplinary punishment, that part I have, in the pleading, I have mentioned it lots. Point lots.
In the synopsis, you mentioned it.
The plead-
Where?
7, paragraph 15 lots.
Page 7. Hmm?
Paragraph 7, page 15. Last 2 line lots.
Page 15.
Page 7, page 7, paragraph 15. I repeat. But the deputy commissioner
Now, where is your appointment order? Who appointed you? Why are you looking at him? Where is your appointment order?
I am withdrawing this point lots. I apologize.
Then you write, the learned counsel thus submits that under the facts and circumstances, the impugn order should be set aside and the petitioner should be reinstated in service with also all consequential benefits. Next para, Mr. R. Dhar, learned state counsel, on the other hand, submits that there is nothing wrong with the impugn orders. Stop. He submits that the petitioner, being a police personnel, he should be aware of the fact, he cannot take the plea that he's not aware of what is there in his pocket. Full stop. While putting on the uniform, the petitioner, being in a uniform force, should have checked about the contents of the same as rightly observed by the inquiry officer. Stop. The petitioner not having done so, he cannot simply play ignorance about the contraband substance recovered from him. Stop. He submits that, moreover, the petitioner has not denied about the recovery of the contraband substance, but rather has put the blame on somebody else, which is not acceptable. To stop, the learned State Council further submits that, at any rate, the acquittal of the petitioner in the criminal trial cannot be the ground for reinstating him back into service, in view of the fact that the criteria or the yardstick in both the proceedings are not similar. To stop, he submits that in a criminal trial, the prosecution is required to prove the case with proof beyond reasonable doubt, whereas in a department proceedings, preponderance of probability is sufficient for imposition of penalty. He further submits that the petitioner, in fact, was not acquitted honorably, but instead given the benefit of doubt due to the discrepancy in the amount which was recovered and the substance which was examined before the FSL. To stop, the learned counsel submits that the petitioner was a member of a disciplined force, and therefore the nature of allegation itself goes to show the undesirability of retaining such person in the force. Stop. He thus submits that the writ petition is without any merit and the same should be dismissed. Next para, I have heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. Stop. At the outset, it may be noted that this court had desired to peruse the departmental records at the very inception of the writ petition. As can be seen from the order dated 18/8/2017. Full stop. However, the respondents could not produce the departmental records as according to them, the same has been misplaced. To stop, the respondents also contended that a special investigation team was also constituted to search and locate the departmental records. Wherein the service records of the petitioner was also tagged along. Stop. However, as the SIT, just put SIT, that special investigation team, I said, just after that, within bracket, SIT. However, as the SIT could not locate the records, despite their best efforts, an FIR was filed as lodged before the Pan Bazaar Police Station, which also ended in submission of a final report without locating the said records. Next para. Coming to the contention of the petitioner that he was not given an opportunity to cross-examine the departmental witnesses. It may be seen that there were as many as 6 departmental witnesses who were examined during the inquiry, which can be seen from the inquiry report submitted by the inquiry officer. Stop a careful perusal of the same goes to show that all the 8 witnesses were examined, but without any cross-examination from the side of the defense, that is the petitioner. However, the petitioner himself was cross-examined after his statements were recorded. The inquiry ended with the conclusion that the charges against the petitioner was proved, requiring him to submit a representation on the inquiry report if he so desired. Accordingly, the petitioner submitted his representation, wherein he again took the plea that he has not been given a chance to cross-examine the departmental witnesses, apart from other grounds. At paragraph number 14 of his representation. Sorry, not representation, at paragraph number 9 of his representation. However, the discipline authority proceeded to dismiss him from service by the impugn order dated 17/1/2017. After 17, you put /18. Okay. Earlier also we had given signed on so and so like that. You should put it as 17/2018. Next paragraph, it is further seen that aggrieved with the order of dismissal, the petitioner filed an appeal before the appellate authority on 9/2/2017, whereby, amongst other grounds, at paragraph number 14, he took the specific plea that during the departmental proceedings, the inquiry officer did not afford him an opportunity to cross-examine the witnesses. This again was not considered by the appellate authority. The appellate authority, as can be seen from the impugn order dated 25/7/2017, had referred to as many as 5 grounds taken by the petitioner, but excluding the ground that the chance of cross-examination was not given to him. The appellate authority thereupon rejected the appeal of the petitioner through the impugn order dated 25/7/2017. Next para. Rule 9 bracket 6 of the rules of 1964 may be abstracted here under for ready perusal. A to A, okay? Page 13. Next para, from the above abstract, it may be seen that in an inquiry proceeding, comma, the inquiry authority shall take documentary as well as oral evidence as may be relevant to the charges under consideration. Stop. While doing so, the delinquent government servant shall be entitled to cross-examine the witnesses examined by the department in support of the charge leveled against the delinquent officer. Stop. However, in the instant case, as already noticed, such an opportunity was not given to the petitioner. Court master. Judgment से तीस लेना, judgment pronounce कर दिया, तो copy तो लग इसलिए आना. Very good. Stop. This court, therefore, is of the considered view that this ground alone would be sufficient for interfering with the impugn orders, since it has resulted into gross violation of the principles of natural justice. Next para. While taking a view as stated herein above, Please cancel that line while taking you. In view of the above finding, it will be a fit case for remanding the matter back to the remanding back for giving an opportunity to the petitioner to cross-examine the 6 departmental witnesses who were examined during the departmental proceedings. Stop. However, the fact remains that inquiry proceedings was drawn way back in 2017. And not only that, the entire departmental proceeding records has been misplaced. And despite all the attempts made by the respondent authorities, the same could not be traced out. Stop. Under the circumstance, it would not be possible to remand the matter back to stop. At the same time, in the absence of an opportunity to cross-examine the departmental witnesses, it cannot be said that the charges leveled against the petitioner has been established. Particularly in view of the fact that the criminal trial has ended in his acquittal. Stop. No doubt, the test of proof in a criminal case and in a departmental proceeding cannot be the same. But the fact remains that disciplinary proceedings as well as the criminal trial was initiated on the basis of the alleged recovery of the contraband substance from the possession of the petitioner and the co-accused person. The petitioner has stated that the co-accused person has not been proceeded with departmentally, and in fact, he has been reinstated after being suspended. It has not been rebutted by the state respondents in their counter affidavit. Stop. Therefore, taking all these factors into consideration, this court is of the considered view that the penalty of dismissal from service imposed upon the petitioner only appears to be excessive. To stop. In that view of the matter, and having regard to the decision of the apex court in Deputy Commissioner, Kendra Vidyalaya Sangathan and others versus J. Hussain, reported in 2013, 10 SCC 106. The penalty to be imposed upon the petitioner is left for reconsideration to the discipline authority. Who shall pass necessary order, consider and pass necessary orders by imposing any other penalty except removal from dismissal from service within a period of 6 weeks from the date of receipt of a certified copy of this order. Stop. The disciplinary authority shall also pass appropriate orders insofar as the entitlement of no. Insofar as the entitlement of the petitioner is concerned, in accordance with law. Stop. It is needless to state herein that the impugn orders dated (18 1/2017) and 25 7/2017 are hereby set aside. Next para, with the above observation and direction, the writ petition stands disposed of. I'll just refine it a bit. This is the broad outline. Okay. This IA is pending. IA. It is dismissed. Yes. Time did you? Even numbers later. 23 Nikki. Remaining items, we are out of time. Mr. Dhar, I was hoping that we'll be able, your item will reach, but
But can it be had tomorrow?
tomorrow there's slight difficulty because
I am there by Saturday. But this case was in fact heard, my lord, by other. But due to positive of some same thing happening here only in every court. So you of time, honorable. That is otherwise simple, your lord. I rely on a particular, my lord, Supreme Court judgment. Same police personnel.
we'll give you a date, Mr. Dhar. I don't think it's practical tomorrow because we have got list already there and some supplementary matters also will be listed. So as far as this court is concerned, I think next week I'll not be here. So that is a problem. You tell me, when do you want it?
Oh, I could be accommodated tomorrow.
Tomorrow is difficult, Mr. Zahab, not tomorrow. See, I'll rise and kindly give the dates which you want. The court master will make the adjustments. All right.